to file 2 appeals without certified copy of the order. Grateful, my lord.
My lord, we'd like to mention a tender matter whether under the risk and the cost of the appellant, a new tender has been floated, my lord.
You
Yes.
want inclusion in the list.
My lord, if it can be fixed, my lord, which is
It's a fresh appeal.
yes.
You give.
My lord, may I have a leave to appeal matter, my lord. Last Tuesday was adjourned for service. Service is complete, my lord. Let the matter be appear, my lord.
Lord, may I be permitted to move this appeal, my lord, without certified copy, my lord? Your lordship, may I be allowed to mention for inclusion?
Inclusion Monday. Already we have collected around 40 to 50 matters.
May I have your lordship's kind leave to mention a matter on behalf of the learned advocate general, my lord?
Yes.
4 analogous PIL matters, my lord, taken up yesterday, my lord. My lord, the returnable date, my lord, comes to my lord 14th of August. He is in some personal difficulty on 14th of August, my lord. If it can be taken up on any day, my lord, subsequent day, my lord, subject to your lordship's kind
So
convenience.
let it come on 14th August. On that day, we will see whether pleadings, everything is complete. Then we will freeze the date.
My lord, grateful, my lord.
Yes.
I have
please.
your lordships kindly, my lord. It's a slightly embarrassing issue, my lord. I am apologizing, my lord, before I mention. But the issue is it concerns, my lord, 2 orders passed by your lordship's predecessor under section 11. Now, my lord, ordinarily, my lord, the review jurisdiction is vested with the learned judge, my lord, who has the determination present. My lord, now, my lord, we are praying for leave to file without certified copy because, my lord, on the original side, once, my lord, the matter is disposed of, if it's a changed brief, one cannot file a wakalatnama to procure the certified copy. But this is our difficulty. But
You got a server copy of
yes,
yours.
my lord, I have got a server copy. My lord, twice we have mentioned before the honorable judge. My lord. We have been turned.
No, the learned judge is not willing to
My lord,
take.
yesterday, my lord, we have been asked to come back. Today, my lord, we have been turned down because, my lord, the honorable judge does not take mentioning today. My lord, I would not have come before your lordship. And my difficulty
Then
is,
we do one thing.
yes,
I'll deal with this in the administrative side.
yes, my lord.
You please give a letter
Yes, my lord.
to the OSD explaining the circumstances.
Yes, my lord.
It will be placed before me in the
Very good.
second
But I am
half.
apologizing because, my lord, the client is
lordship-
80 years old. My lord, he's carrying a walking stick in the honorable court. But this is the difficulty. I shall procure the letter. I'm very good.
lordship.
May I be permitted to mention one appeal matter? It was adjourned for the service. Now service has
Service complete, yes.
My lord, may I have my lord's leave
Your
to
lordship-
mention a PIL matter, my lord? My lord, this is,
What is the urgency?
my lord, urgency is that on the first date, the Honorable Judge, ex-Chief Justice Rajeshri Bhal, my lord, I apologize, my lord, for my
No
mistakes, my
problem.
lord.
Yes.
Therefore, my lord, thereafter, my lord, the bank, the bank was ordered to file a report in affidavit within 3 weeks of the date,
You give the letter, let us see.
my lord.
Your lordship, sorry for the indulgence.
Yes.
Yesterday, a PIL matter was moved. It was fixed on 14th, but there is a confusion regarding the supplementary affidavits and all. So what should we do? We could not able to understand.
No,
your
no,
lordship.
your matter will come on 14th.
Yes, my matter will be come on 14th, but your lordship
Yes.
has
Ah.
given order that complete the affidavit of service and all that things. supplementary
Everything
affidavit
by
and
then.
all.
Nothing after 14th.
Nothing after 14th.
Yes,
Okay. Deeply obliged, your lordship.
yes.
Appellate side, daily list, serial number 3.
Yes. Sir, you are not audible. Disturbance. Whether service has been complete? Service of notice. I think there's some problem in your end. The video is clear, but audio is not there. There in problem. The notice has been served on the respondent. Where is the affidavit of service? file the account for service. We'll adjourn it by a week. Just excuse me, the same caption. Account for service be filed by then. Next,
Serial number 4.
next Tuesday will be first.
My lord, I don't know.
Serial number 4.
I am praying for not today, my lord.
Why?
Due to illness, he could not come to the court, my lord.
What is the prayer we have sought?
Advocate for the learned
Steps to
petitioner.
stop the illegal activity, supply of drinking water from the installation of Sajal Dar project.
Learned advocate for the petitioner.
And who has to consider your representation? Let the representation be
My
considered.
lord,
Your
Mr. Samrat Shen, learned senior advocate is appearing, but I'm praying for not today, my lord. For item number 4.
the learned advocate for the petitioner as well as you are for the contesting respondent.
My lord, state respond.
State and the learned advocate for the state both seek adjournment. List next Tuesday. Same position.
Serial number 5.
But I am for the petitioner.
Yes.
The most of the answering respondent has been served.
Hmm.
Private respondent, four, it has came back as insufficient address.
What is the toxic waste he is releasing?
Yes, kindly come to page 40 for once.
40.
Yes. This is a pending appeal before your lordship. This is also is in your lordship's list in the monthly list. Kindly see the order at page 40. May I read it out?
Yes, we have read it. Now order has been passed by the Pollution Control Board.
Yes.
In spite of that,
the Pollution Control Board stopped one mill because they didn't have any infrastructure. 4 mills, they didn't have the process to filter the water or the toxic water. So they were asked to install the new machineries, and the old machineries has to be replaced within 30th of June. That was done. That was the order passed by the pollution control. Thereafter, what they did is, they have excavated the drain in concern. What was the challenge in the earlier appeal also, saying that as if the highway authority was in the need of doing that. Now, in this way, what they have done, the order passed by this honorable court as well as the order passed by the Pollution Control Board, that has been frustrated because they have not changed anything. The toxic water, which was supposed not to be allowed in the river, that was allowed by this drain, constructing this drain. Now it is flowing through this drain, and highway authority, they are saying that as if, kindly come to page.
But the drain has not been closed till date.
No, drain has not been closed. Nothing has been
Who will
done.
appear for the Pollution Control Board?
I am for the respondent number 15, one of the mills,
And what have you done? Have you complied with the direction issued by the Pollution?
Perhaps this picture will clear everything.
So I have annexed
has excavated a drain, and at the instigation of these people, it is closed. Your lordship kindly sees,
That is true, but have you complied with the pollution control norms?
They have there is a direction, I have taken step, it's going on. and
No,
within
no,
the
no.
stipulated.
You have to comply and then run.
Yes, yes, everything I will comply, my lord, because I will have
Without
to
complying with
carry
the,
on business there, my lord, and I am carrying on. Unless it happens, my lord, sometimes some norms, my lord, goes beyond the parameter.
no,
my lord,
it's not, it is non-negotiable.
my lord,
It's non-negotiable.
they cause an inspection, my lord, they direct us, and every time we comply with it, and this time also, my lord, I've complied.
Well, that has not been complied.
You please come to page 59. This is a closure order.
This is a closure order in respect of a particular mill for whom I am
No,
not
no,
representing.
you are appearing for the 15th respondent. This is a closure order of your client.
Mal.
Page 59.
Mal.
What have you done thereafter?
My lord,
How are you operating the mill without,
that my lord, in that even, my lord, what exact step I have taken in the meantime, my lord,
see, they have ordered for closure.
Mal.
And they would have set down what are the norms. You comply with the norms, you submit a compliance report.
Mal.
They will inspect, and thereafter only you can run.
My lord.
By this writ petition, the petitioner has highlighted as to how the private respondents who are rice mills are discharging toxic effluent into a drain. Earlier, the mills are alleged to have been discharging the toxic effluents into a river. And based upon complaints given,
This is only in respect to, my lord, respondent number 15, my lord. Others I am not.
others are all there. Series, you go through the papers properly. Complaint, the West Bengal Pollution Control Board had taken
Others,
action
connection.
and
My lord,
issued
subject-
orders for closure. The petitioner has enclosed the orders, the copies of such orders along with the stay in the stay application. The further allegation is that a drain has been dug along the highway and
My lord, removing the footpath. There is no footpath.
the toxic waste and water are let into the drain. The learned advocate appearing for the 15th respondent rice mill submitted that the submission of the petitioner is factually incorrect and the drain has been closed. In this regard, a photograph has been placed before this court. Be that as it may, as long as the order of closure passed by the Pollution Control Board has not been revoked, altered or modified, the private respondent rice mills are not entitled to carry on their operations. It is not clear as to why the Pollution Control Board has not made any further inspection in the matter. Therefore, there will be a direction to the appropriate authority of the West Bengal Pollution Control Board to immediately conduct a surprise inspection of all the respondent rice mills. And if it is found that despite the order of closure or in non-compliance with any of the directions issued by the Pollution Control Board, the rice mills are operating, action should be immediately taken against those rice mills. In the event the rice mills comply with the directions by establishing appropriate effluent treatment plant and after complying with other conditions, then only the Pollution Control Board will be entitled to permit those rice mills to operate, to carry on business. The surprise inspection shall be carried out not later than 10 days from the date on which the server copy of this order is received. With the above observation, question disposed.
My lord, I have only one prayer. My lord, the drain is of 4 kilometers. The picture is showing a showroom is, my lord, only.
In the event a drain has been illegally constructed, direction should be the Public Works Department shall take immediate steps to close the drain.
My lord, I am representing for the state. My lord, what is happened that with respect to the construction of the drain, My lord, my instructions are that these are all existing, and my lord, may I just please report to the effect?
No, if the drain was meant for something else, then it is all right. If the drain was cut out and these people are leaving the effluent water into the drain, you have to close the drain.
My lord, what has happened? This is exactly the drain that was existing. It was a kacha in nature. Within that periphery, as it has been demarcated, first we have get it demarcated to the
Then please
PLR.
come. That last sentence you strike out. The learned advocate appearing for the respondent state submitted that there was a drain along the national highway, which was a kacha drain.
My lord, kindly come to page
Exactly, we
60.
have renovated, my lord. May I please this reports, my lord? Exactly what we have done, we have given the picture also. Actually, that is within that highway, we are making the expansion within that area only. We are demarcating, my lord. What is the
No,
demarcation?
no, we are not concerned about that. We are concerned about these
Yes, yes.
people.
My lord, because the allegations has been made that we have
My lord, may
Which has
I
been
say two
developed.
things?
no new dug up or
My
nothing.
lord, it is completely new because from the
You
orders.
cannot object to the construction of the
My lord,
drain.
I'm not.
You are
doing it.
concerned about discharge of effluent
Yes.
into the drain, which is illegal.
My lord,
lord,
my
so
second
far-
concern is, my lord, my lord, I made the prayer, my lord, because it's a kacha drain and no, my lord, space has been leaved. My lordship will find from the pictures, already 3% died because of that. Only thing is, my lord, a covered drain to be done. My lord, I have no other.
Kacha drain, which has been now repaired by the West Bengal Highways Development Corporation Limited. And in this regard, a report filed a report of the project director dated 27/20/23 has been filed. The learned advocate for the petitioner submitted that the drain is posing as an hazard, and 3 people have lost their lives
Yes.
by falling into the drain. This aspect shall be noted by the West Bengal Highway Development Corporation Limited, and the safety of the general public of the area shall be taken care of, disposed of.
My lord,
Next,
only one line, the covered drain to be, that covered thing.
we can't do
Otherwise,
that.
my lord.
My lord, so far page 69 is concerned, my lord, closure order was, my lord, only in respect of one mill, my lord, not in respect of other mills.
It is there. You please see the other pages. Next,
Serial number 6.
My lord, I'm appearing for the petitioners in serial number 6, my lord. This is concerning
illegal construction in wetland.
illegal construction, reclamation of wetland and water body, as well as abandonment of water bodies, my lord. We have brought specific
And who's
instances.
putting up the illegal construction?
My lord, we are not aware of the actual perpetrators. We brought it to the notice. Specific
Where
instances.
is your representation?
My lord, my representation of the specific instances are at page annexure P3 at page 50.
50.
50, my lord.
What was the response of the authority?
My lord, in the case of a bridge construction over a canal,
Hmm.
here the specific action taken by the respondent was that they stopped the illegal construction.
Very good.
But my lord, these canals feed wastewater to 60 fish ponds. And out of these fish ponds, there are several, around 2000 fish workers are dependent, their livelihood is dependent. In fact, my lord, this sewage treatment as well as pisciculture is the core reason why these wetlands became internationally renowned and under the Ramsar Convention and are protected also under the 2006 Act. So, my lord, not only stopping the illegal reclamation, but restoring these canals are also paramount. And
Now they
here,
have
my
stopped-
lord, the respondent stops,
Now
unfortunately.
they have stopped the
Illegal construction, as far as the first instance,
they
my
have
lord,
remove
has
the
stopped.
debris
No,
and
my
make the
Yes,
canal.
that has not happened. And the second instance,
I am for the Kolkata Municipal Corporation. This is basically the duty of East Kolkata Wetland Management Authority.
All right. Who will appear for that authority? You will appear.
We appear for the state. I'm led by Mr. Somnath Ganguly. That should be appear for the state.
All right. Let them see now that illegal construction has been stopped. You remove the debris, allow the water to flow. That's all he wants.
my lord, if I may, my lord, there are two more
To what are
points, my lord. The second instance is more alarming, my lord. This is with respect to
No, that wetland authority is not a party.
Yes, my lord. They are second respondent, my lord.
Second respondent.
Wetland authority is very important, my lord, because of
Yes. Wetland Management Authority.
Management.
Then what is the second grievance?
Second, my lord, is several water bodies in Dokhin Dhapa, Manpur, Moja, my lord, are under tremendous pressure. Whenever the police comes, they stop construction, as in filling up of the wetland, and they run away. Again, when there is a FIR already, my lord. Again, when the police leaves, they'll come back and start doing it. They are already, my lord, recent status is that they have already encircled the water body and a boundary wall has been constructed. All this is happening under the nose of the authority, my lord. Though they are taking action, again, my lord, what they are stopping at is restoring, my lord. And that is not happening. And there is a problem, my lord. Even they have enacted a management action plan. East
What we
Kolkata
can
Wetland
do is
Authority.
we can ask the second respondent to first restore the channel
Yes,
by
my lord.
removing the debris, and probably form a vigilance team or some team which will maintain vigil of that area,
My lord.
so that no further damage is done to the wetland.
My lord.
As of now, we can do.
Kindly, my lord, to one submission, my lord. My lord, they have come up with a management action plan as well, my lord. And they have looked at the downward trend of how fishery cooperatives, government as well as private has decreased. They have also spoken in the management action plan. I have provided extracts of the same, my lord, about how to utilize West Bengal Inland Fisheries Act to take over abandoned fisheries where pisciculture is possible. But this requires coordination of the departments, my lord. I have placed on record a High Court order, my lord.
For the present,
Yes,
this direction will
it is.
issue. We will
My lord,
issue this
survey should be conducted of all wetland reclamation that
All
is
right.
going on, and it should be
By
stopped
this
immediately.
writ petition, the petitioner has highlighted the several issues and several issues relating to the wetlands in East Kolkata. The petitioner, the villagers had given representation on the representation on various dates.
As well as the petitioner, my lord. Both the community as well as the
The
petitioners have provided
petitioner as
representation.
well as the villagers had given various representations to the authorities, and the representation and our attention has been drawn to the representation dated 7th December 2022. It has been pointed out that the persons who have made the representation are the wetland community that earns livelihood using the sewage water of East Kolkata wetlands, Ramsar site. And since October 2022, efforts are being made to construct a permanent bridge by which will result in narrowing the sewage carrying canal. And this will affect more than 60 berries that depend upon it. And more than 2,000 families are sustained by those berries. And if the construction is put up, the flow of the water will be obstructed, and consequently, physical operations will be affected. It is submitted by the learned advocate for the petitioner that pursuant to the representation, the authorities, more particularly the second respondent, has taken action, and constructions/illegal constructions have been stopped. However, the grievance is that though such illegal construction had been stopped, the canal has not been restored to its original position by removing the debris and other structures which were put up
Five is point number 5.
for the purpose of making the illegal construction. The second aspect which has been highlighted by the petitioner is that there are several such wetlands which are being used for pisciculture, and several families depend upon the same. But however, miscreants are illegally putting up construction, and whenever the authorities or the police officials visit the place, they stop construction, and after the authorities leave the concerned place, the construction activity is commenced once again. Therefore, it is submitted that the second respondent, which has already drawn a management plan, should effectively implement the said plan and ensure that no illegal construction or filling up of the wetlands or the channels leading to the wetlands are being done. We have heard the learned advocates appearing for the respondents on the above submission. Now that the illegal construction put up on the wetland pursuant to the representation dated 7th December 2022 has been stopped, it goes without saying that the second respondent authority should ensure that the canal is restored to its original position. Therefore, there will be a direction to the second respondent to immediately take up the work of restoration of the canal to the original position by removing all the illegal constructions which were put up, and such operations shall be commenced and completed within a period of 3 months from the date of receipt of the server copy of this order. With regard to the second grievance expressed by the petitioners, namely with regard to illegal constructions being put in wetlands in various places in and around the area pointed out by the petitioner, since a management plan has already been drawn by the second respondent authority, what is required is effective implementation of the management plan
in a coordination with other departments.
And this will be possible only if the second respondent acts in coordination and in conjunction with the other departments of the state. The court would opine that a vigilance team can be formed by the second respondent authority by drawing officers from the environment department as well as from other departments, including including officials from the office of the district magistrate, as well as the officials of the Department of Fisheries. And this vigilance team shall be assisted by the concerned jurisdictional police so that they can make periodic visits of various areas by conducting surprise inspections, and wherever illegality is being, wherever illegal construction is being done, or wherever there is blockage of any water channel, the same shall be immediately looked into, and such illegal activities be stopped, and the persons and action be taken, and action be taken against those persons who perpetuate such illegal activities. Thereafter, the illegal construction should directed to be removed by the person who has put up the same within a time frame. Upon his failure, upon his or / their failure to do so, the construction shall be removed by the department themselves, and the cost be recovered from the persons who have put up such illegal construction. That apart, criminal cases shall also be registered against such of those persons who have illegally put up construction in such wetlands, as well as blocking the water channels.
My lord, may kindly
Such a vigilance team shall be constituted within a period of 8 weeks from the date of receipt of the server copy of this order, and effective steps be taken by the said vigilance team, bearing in mind the observations made by this court in this order.
My lord, petitioner number 2 himself is is from the wetland community. He may assist the vigilance committee in spotting wherever we have been able to locate.
It will be well open to the said vigilance committee to co-opt one of the petitioners, as it appears that the petitioner has sufficient information with regard to the activities which are being carried on in the said locality. Next, disposal.
Serial number 7.
Item number 7, my lord, I am appearing on behalf of the petitioner, my lord. I am led by Mohammed Sabir Ahmed, my lord. The affidavit of service.
Install deep tube.
My lord, our prayer to installation of a deep tube well for the purpose of supply of, my lord, drinking water amongst the 3 villages, that is Talbangru North, Talbangru South, and Talbangru West, my lord, within the, my lord, district of Malda, my lord. My lord, since the district of Malda is affecting from, my lord, arsenic prone area, my lord, there are
the petitioners are the villagers concerned of the village are facing, my lord, scarcity of drinking water. My lord, this issue had been brought before this honorable court, and this honorable court had
Page
specifically,
21. Page 21.
my lord,
Hmm.
had specifically directed the state respondent to installation, because, my lord, there are 15,000 residents amongst the three areas, and, my lord, there are
No,
only
if
one, my lord.
No. If according to you, the groundwater contains a high percentage of arsenic,
My lord.
unless they have a filtration plant or something like that.
No, my
only
lord, that
it
is
fits
that is up to particular depth. That is why it is required a deep tube well that only conducted by the PHE, my lord, the concerned department of the state concern, my lord. And this honorable court has specifically directed to installation, because there among the three villages, my lord, there is only one deep tube well from where the water, drinking water, has been supplied to the.
This order was passed on 20th December 2012.
My lord.
And thereafter they have put one deep tube well.
My lord.
And that is not sufficient. to
No,
get
that is not sufficient, my lord. One portion of the three villages, my lord, they are facing severe scarcity of drinking water, and it has been reflected from the order sheet of this honorable court. And thereafter, my lord, a writ petition has also been moved, my lord. That is appearing at page, my lord,
23.
My lord. My lord,
Not 23,
our
22.
22, my lord, 23 onwards, my lord, 22 onwards, my lord.
Oh, yes.
20
And what happened after this order? This
My
order
lord,
was.
we have no effective steps has been taken to install the second, my lord. And one
What
more
is your
thing,
After that, my lord, already this is the nature of private litigation, my lord, what they are
my lord,
submitting,
one
we
more
are
thing,
submitting
that
two reports.
one of the villagers has extended the help by providing the land, on which, my lord, the state respondent can install the, my lord, deep tube well. No, it is only for the purpose of the, my lord, supply of drinking
My lord,
water, nothing else, my lord.
You give a copy to your friend.
My lord, we will provide one. My lord, actually, my lord, if your lordship kindly takes up, my lord, the R1 first. There was already a subsequent order.
That is correct, sir. Thereafter, what happened?
Thereafter, yes, my lord, our report at the third page, my lord, third page of the report, my lord, lordship kindly see, already steps has been taken, a place has been procured.
Now they are telling for.
Now they are, what they are submitting is something extra than that. Already second tubal, it is there. It is already been done. We have taken enough steps, my lord, the last two paragraphs of the report, my lord. We have procured the land for the installation purpose, everything. To cater the local people, my lord, steps has been adequately taken, my lord.
No. What is the order dated 4/7/2022? You are referring to some 4/7/2022 order. What is that? There is no such order.
2022, my lord, R1. My lord, just immediately next page. The first page after the report. That is R1.
So that was filed by somebody else.
Somebody else. Of the same area.
Hearing the learned counsel, so and so, the view can be disposed of directing the fourth respondent, Superintendent Engineer, North Bengal Circle, Public Health Engineering Directorate, to take expeditious steps in the construction of tube well in plot 2439-2440 within four weeks. Shall decide the plot on which the construction will be made, but the construction should be within the time frame as directed above. Now, till now, you have not done. Still, you are only.
My lord, we have taken steps already. That is what.
No. The time limit was you are in contempt.
My lord, my lord, already so far my.
From 2012, these people are in.
My lord, we have to take out a plot, my lord. We have already done it.
Funds for so many other things. You don't have funds for this.
My lord, this is not of the funds. We have done it, my lord.
No, you have not done it. You see your report. It's absolutely wishy-washy. You see this report. Now the last page of that report.
Since my lord, the last but one paragraph, since the.
Now the present writ petitioner filed the incident so and so, nature of public in so and so, proposed tube well in so and so LR plot number. Under the circumstance execution of Malda, wrote to the additional district magistrate and so and so, on 18/7/20 to get the nature of the land ROR so and so plot number for deciding the suitability. This is in respect of a land which somebody is offering. He says that, sir, please construct in mine. As per the direction issued in this order dated 4/7/2022, already you have identified 2 plots
Yes.
that you have not complied with.
Well,
So we issue notice of contempt.
Well, to my instruction, this phase is already the second tubal, my lord. If you lordship kindly takes up the last paragraph, my lord.
You read.
Since the PHE department in compliance with the order dated such and such passed by the Honorable High Court at Calcutta in WPA number such and such has already taken adequate and sufficient measures to get the suitable plot of land for installation of the second tubal in Talmana Moja
No.
as demanded by the people.
What is the direction is? You have identified 2 plots, 2439, 2440. Direction was you do it within 4 weeks.
My lord.
Therefore, respondent shall also decide the plot on which construction of tube well will be made. This is, I'm reading the order. But the construction should be within the time frame as directed above. Still you are dragging on the matter.
In the basis.
All right.
May I to the point out to the second paragraph of that particular page, my lord. On the basis of the second hearing, the executive engineer Malda White such and such wrote a letter to the additional district magistrate for processing plot number such and such. There was a process, and after that, for finalization, deed of gift, these have already everything has been done.
No, water has not come.
That may be, we may. My instructions are, it is at the fag end of the, it will be perhaps.
There are 2 plots, 2439. What do you say? Last page. According to this department, was compelled to forbear the proposed construction in the well and plot 2439. Kaitan number so and so, petitioner Abaidur, and accordingly, second hearing the meeting was conducted so and so. As per the orders, you decide to construct a tube well in 2440. You construct it within 3 weeks and file a report in 2440. Then we will see about the remaining. Otherwise, we will issue notice of contempt.
Because already the process is done.
The petitioners who are residents of Tal Bangura village are before this court ever since 2020, ever since 2012. For a basic amenity, namely safe drinking water. It is submitted by the petitioners that the groundwater in the village and in the neighboring areas has high arsenic content, and to have good quality potable water, a deep tube well has to be installed. For in the said area, the petitioners would state that there are more than 15,000 people residing, and there is only one deep tube well, which is insufficient to cater to the drinking water needs of the people of that locality. Therefore, repeated representations were made for construction of additional wells. The first writ petition was filed before this court in WP 10096 within bracket W of 2012. The Honorable Division Bench by order dated 2012-2012 directed the district level authority, Public Health Engineering Department to look into the grievance of the petitioners and takes effective steps for removing the scarcity of water, as it is the bounden duty of the respondents to provide adequate water, particularly during summer. The court also fixed a time limit for considering the time limit of 3 months for complying with this direction. It is seen that till date, the order and direction issued by the Honorable Division Bench dated 2012-2012 has not complied with. Once again, another petitioner approached this court by filing WP 1012 within bracket W of 2016. Seeking for a direction upon the superintending engineer of the Public Health Engineering Department to consider the representation which was made for providing potable drinking water to the residents of the area. The writ petition was disposed of by order dated 3/2/2016 by directing the authority to consider the representation and pass a recent order within a time frame. Though such an order had been passed on 3/2/2016, till date no effective steps have been taken by the authorities to provide safe potable drinking water to the residents of the area. Mr. Ganguly, learned advocate, government advocate appearing for the respondents, has submitted a copy of a report, filed by the executive engineer, Malda Division, Public Health Engineering Directorate Department. Dated 19/7/2023. Sorry, sir. Before that, this sentence you keep it before that. Thereafter, another writ petition was filed before this court in WPA 12434 of 2022 by one Abaidur, Abaidur. The learned writ court took note of the direction issued by the Honorable Division Bench in the earlier writ petition and pointed out that the said writ petition had offered his land for construction of the tube well, and he is unable to get the tube well installed for almost 6 years. Therefore, there was a direction issued to the superintending engineer, North Bengal Circle 2, Public Health Engineering Directorate, Malda, to take expeditious steps in construction of tube well on the land in question, being plot number 2439 and 2440 within a period of 4 weeks. This order and direction has not been complied with till date. From the report submitted by the executive engineer dated 19/7/2023, it is seen that the authorities are still dragging on the matter. Insofar as plot number 2439 is concerned, it has been found to be not suitable for putting up of the tube well. However, the authorities have affirmed in the report that the tube well will be put up in plot number 2440. In fact, in terms of the directions issued in WPA 12434 of 2022, dated 4/7/2022, such tube well should have been put up within a period of 4 weeks. Thus, the authorities, namely the authorities of the Malda Division of the Public Health, Public Health Engineering Directorate, are liable to be punished under the provisions of the Contempt of Courts Act. Be that as it may, in the report it has been stated that steps are being taken for finalization of the gift deed and departmental transfer of the land for taking up of the work of construction of the second tube well in plot number 2440. In the light of the stand taken by the authorities in the report dated 19/7/2023, we direct the executive engineer, Malda Division, Public Health Engineering Department, to complete all formalities for departmental transfer of the land in plot number 2440 within a period of 3 weeks from the date of receipt of the server copy of this order. Thereafter, immediate steps shall be taken for constructing the tube well in the said plot, and such construction shall be commenced and completed within 3 weeks from the date on which the departmental transfer is completed. A compliance report in this regard be filed before this court in this writ petition.
But in addition to that plot, I have also offered a plot, that is plot number 3029. That if they feel any inconvenience in that plot, the lordship would kindly take, add one line that page 24 may be also taken care of. If
The learned advocate for the petitioner submitted that in addition to plot number 2440, the writ petitioner has also offered one more plot in plot numbers 3029. The authorities can also take into consideration the said offer made by the petitioner, and then and the needful be done, and a report be submitted before this court on the next hearing date. List the matter on so and so date.
obliged.
Just to 6 weeks. After 6 weeks, you give it. Next.
Serial number 8.
In this matter, I appear for the private respondent matter.
My lord, I am for the petitioner. The petitioner's allegation is, my lord, the private respondent is carrying on scrap iron business, which is illegal. My lord, the police has, my lord, seized that. My lord, you will find that
Scrap business is illegal, is it?
my lord, they are collecting the scrap iron illegal, stolen iron.
Iron ore.
Yes. My lord, that has been reflected in the report at page 14.
From where they are stealing this iron ore?
Well, that I do not know. That police person can say that. It is
But,
police report.
We have come across cases of stealing of coal. That we have come across. Then illegal quarrying of river sand. That has come to our notice. But
This is iron scrap. My lord, criminal proceedings had been instituted. My lord, truck, my lord, had been seized. Go down, my lord, had also been seized. Now, my lord, they applied for release of the truck. My lord, that, my lord, the court has allowed. They kindly see their prayers that this is what the criminal court should do and this is what the criminal court should not do. Page 8. Page 7, my lord, onwards, my lord, it starts. And my lord, 2 persons had been arrested. My lord, they have been enlarged on bail. And my lord, it's really, my lord, this kind of a, my lord, PIL, my lord, relating to, my lord, work of property, something happening there. My lord, the people come, my lord, and make.
Private interest in
That is private dispute. It was clearly private dispute, my lord. And my lord, the police here have taken steps.
This scrap iron has been procured from which place?
My lord, it would be, my lord, what happens?
No. Still, they say, how can somebody dealing in iron scrap be illegal?
My lord, per se it is not. Per se it cannot be.
Yes.
My lord, but my lord, if my lord it is stolen and then being traded, or my lord, if a license or a my lord transport permit is required, it's not there. My lord, those are my lord the kind of
individual cases
correct,
take action.
Correct. Now, my lord, it's not my lord iron ore that without a mining license, my lord, ore, my lord is my lord.
That's what we thought.
No, my lord, that's my lord, it's my lord scrap iron. Which are
Well, the report says, my lord, it is the last 4 lines of the first paragraph.
Page
14.
14.
Last 4 line of the first paragraph.
Yes.
I interrogated him several times, and on interrogation, he confessed that he used to sell stolen iron scrap in lieu of money.
That is correct. These are all individual cases. Suppose a truck is intercepted and the authority asks him to produce the documents. He is unable to produce, they will take action in.
Yes. That is my
The
my prayer is
petitioner,
also the same.
by way of this public interest
After filing of
petition,
this writ application, the go down which was sealed, that has been unsealed.
some court order might be. By this, the petitioner has filed this writ petition styled as a public interest litigation, alleging that certain third parties have been illegally dealing in iron scrap. The petitioner has also mentioned a truck, the registration number of a truck, which was alleged to have been used for transportation of the stolen iron ore. The learned Advocate General appearing for the respondent state pointed out that action has already been taken and criminal case has been registered. The accused were arrested and remanded to judicial custody, thereafter been enlarged on bail, and the jurisdictional court has issued orders releasing the vehicle which was carrying the stolen iron scrap.
And the Millard scrap iron is still in the custody of the police.
The
stolen.
stolen material, namely the iron scrap, is still in the custody of the police. Further, it is submitted that the godown which was used to store the illegal scrap iron, stolen scrap iron, was sealed. But however, pursuant to court orders, the seal had to be removed. In the representation given by the petitioners through their advocate,
Millard, regarding Millard, unsealing of premises, there is no court order. Millard, after inquiry, finding nothing illegal there, Millard, Millard opened it and we are keeping a strict vigil. Millard, I have that.
The godown has been unsealed, not court order. That, in the representations filed by the petitioner through their advocate to the police authorities, names of certain persons have been mentioned, and who are alleged to have been carrying on the business of illegal scrap iron on the eastern side of the 12 feet village road. That is on the western side of the road, Lohania, Lohaniya Masjid has been established. Full stop. In the light of the fact that in one of the cases, action has been initiated by the authorities, there will be a direction to the respondents 2 and 3 to conduct surprise checks of all the vehicles transporting all the vehicles and also the godowns in the area, so that such illegal activities are nipped at the bud. With the above observation, the writ petition is disposed of. Next.
Serial number 9.
I beg to appear on behalf of the petitioner. This is a case, restoration of the water body. Near the adjacent to the Baruipur railway station. A long, big type of water body which has been the sum of the dumping of the garbages to the pond. And thereafter, this restoration has been kindly come to the page 106, 12/3/2020. The senior divisional railway manager also directed to the Jalasoy Bachao committee to restore the pond. And thereafter, it was the keep it pending. And it was also the environment department 102 page, the directing the municipality and other department, fishery department to restore the position of the water body.
And who's dumping the waste?
Dumping the some of the club situated club is situated Pragati Sangho club. I have party to the petition. He is situated on the just near to the railway station. They have been dumping the garbages over there and trying to fill up the pond, and illegal construction has been made over there.
Yes, sir. What is your?
And I am appearing for the West Bengal Pollution Control Board at page 101, my lord. We requested the BDO,
yes,
my lord, to take steps in accordance with law, and thereafter, my lord, the Department of Environment, my lord, also at page 102.
So the railways have also written. You are appearing.
I am appearing for the Baruipur municipality, my lord. My instruction is that, my lord, we have also written letter to the Eastern Railway that this land belongs to the Eastern Railway. They have to take steps. And my lord, from the page 104 onwards, my lord, if your lordship kindly see from the writ petition, your lordship will find that Eastern Railway has also communicated that they are already taking steps. If your lordship kindly see.
But the railway has written to Jalse Bachao committee. What is that committee?
It's a committee, my lord, set up, my lord, in order to, my lord, preserve these water bodies.
And it has got a statutory backing.
No, there is no statutory body, but this is committee formed by the some of the local village people.
How
but-
they will,
Well,
who will spend on?
Well, this has been directed to instructed me to expend to own my own expenses.
My lord, if your lordship kindly see page
Oh.
1051.
105.
My lord, this is the letter written by the Eastern Railway to the Shore Metro advocate who made the representation on behalf of the petitioner. Competent authority had already accorded approval for cleaning of the water bodies surrounding such and such at Barupur station and removal of garbage from backside of such and such, make it pollution free on the basis of convener Jalshaya Bachao Committee, Barupur representation. So regarding this issue, this committee has already made a prior, my lord, representation. So accordingly, they have given permission, accorded permission to that committee to take up this work.
But that committee, who will fund that committee?
That is also, my lord, probably a public spirited.
But can you not assist them? Probably the cost can be directed to be paid by the railway.
If your lordship direct us to do so, we will do so.
But what is the extent? Large extent?
Large, there are two big ponds.
No. How this club can dump such a huge pond?
For personal capacity.
Personal gain.
For the personal gain, my lord, they have.
That is correct, sir. Then they should be getting debris from outside and dumping it. But who will bear the cost of removal?
My lord, the cost of the removal, my lord, should be paid, my lord, the Bachao committee, who are my lord, authority. Otherwise,
But you
railway,
said that-
my lord, the competent authority.
Capacity.
Railway is my lord, the competent authority. Railway, my lord, the land to the
railways.
covered by the railways.
But who appears for the railways?
Well, the railways I have served, my lord.
Where have you served? Where is your affidavit of service?
Service railway ke service করেছি।
Railway service.
Where? Show proof of service.
General manager, DRM.
General manager,
DRM.
You should have served it on the divisional engineer. What the general manager sitting in Kolkata will do. You should have served it on the divisional engineer, Eastern Railway. Where is the acknowledgement? All right. The learned advocate for the petitioner is directed to serve the learned standing counsel for the Eastern Railway. List the matter on Mondays. And also the 12th respondent, 21st respondent, namely the private respondent, and file affidavit of service. List on Monday, same position. Next.
Serial number 10.
I appear for the petitioner. Lord, this relates to the recently concluded panchayat elections.
For the number 12.
And more particularly, Lord, with regard to number 2, Bishnupur Gram Panchayat under Hemtabad Panchayat Shomiti. Lord, right from the date of Lord, filing nominations until Lord, the date of counting, Lord, the reign of terror that was unleashed by the Lord, ruling party and its workers, Lord, is a subject matter which has resulted
in fact, yesterday we have heard the batch of matters similar to such relief in where the prayer has been made for a particular area.
My lord.
This is, some have said, set aside the entire thing for general prayer.
My lord.
And similar prayer, like this is Bishnupur Gram Panchayat.
My lord.
We will direct the respondents to file their affidavit and we list the matter on 14th August.
My lord.
My lord, I think in the morning, my lord, it was mentioned 14.
Yes. So we said on 14th, they said, I learned an advocate general.
Yes, my lord, I have a my lord, personal problem that day, my lord, 16 subject to your lord.
So let the matter come up.
Yes, your lordships want to see everything completed.
Yes. And close the doors.
Yes.
Then we
well.
start here.
Very well.
No more for further entry.
And my lord is not passing Lord an order, but that the results Lord would be subject to the
That is all
That's already
that is applicable.
That's already there, my lord. My lord. This, in fact, my lord, this petition, my lord, there's nothing.
Except our earlier order.
Yes.
That's all. What to do? Some people, who is the petitioner, sir?
Lord,
He's
they are
from
not the local residents Lord,
local
of,
residents.
and voters.
And have you served the election commission?
Yes.
Nobody.
I think Sonal Sinha thought everything is over.
Election commissioner jonno ke ache? Election commission.
One more copy you can serve.
Sonal Sinha thake to.
20. You inform her.
I shall inform.
The learned the learned advocate for the petitioner submitted that the respondents have been served in the matter. Since connected writ petitions are to be heard by the court on 14th August, let this writ petition also be clubbed along with the said batch. In the meantime, the respondents are directed to file their affidavit in opposition to the allegations made, and advance copy of the affidavit be served on the learned advocate for the petitioner well before the hearing date.
I'm grateful, deeply obliged.
Just on 14th August. Next.
Serial number 11.
Your Lordship,
My lord, here kindly
Your
have a
Lordship,
look at prayer. page.
item number 8,
Have a
11,
look
Your
at
Lordship, I'm for the petition, Your Lordship. I pray Your Lordship liberty for face file, Your Lordship, because Your Lordship, some factual error is there in the petition, Your Lordship. And
You want to withdraw
yes, Your Lordship.
with liberty. is it?
Indeed, Your Lordship.
Lordship
Face-
says prayer
Some
team.
factual error is
Just
there in the
prayer
petition,
team.
Your Lordship.
To
Board-
issue certificate in favor of the winning candidate.
That is the petitioners. And my
No,
lord, it's a combined petition,
Ah.
my lord, by the CPIM and the BJP candidate. Together, my lord, they have, my lord, filed the petition.
No, actually, there are writ petitions filed to quash the certificates.
No, Lordship, what has happened in this matter, Lordship, I got some other information, Lordship, those things has to be tagged with it. And Lordship,
No. Now, so far as these people are concerned, they say all is well with the election.
Correct.
We won't allow you to withdraw.
they say
There's
that they were
unless with the
the
leave of the
winner,
court, you can't withdraw.
they were the winner. It's a new trend of rigging. That capturing the counting stations,
No.
stations, and this has happened, all these things have happened in counting stations.
No,
Somebody has been winner.
no, petitioners have been declared as winners.
No, they want a declaration. They said somebody else was declared. We thought we
They
were,
were the winner,
we thought we were
but
going to win.
instead of them, somebody else have been declared as winner. This is the thing.
This
All
is-
videos are involved, and these are captured in the
All right, the
CCTV
learned
footage.
advocate for the petitioner seeks permission to withdraw this writ petition on account of certain factual errors which have crept in, with liberty to file a fresh writ petition. Considering the said submission, the writ petition is dismissed as withdrawn with liberty as sought for. Next.
Serial number 12.
Item 12. None appears for the petitioner. Dismissed for non-prosecution. Next.
Serial number 13.
I am for the petitioner, Lordship. This is very unfortunate.
My lord, Mr. Samrat Sen is appearing for the state respondent. I am praying for not today, my lord.
And I beseech your Lordship to take this suo cognizance if your Lordship wants. This is the video of this incident which is coming in a lady and pen drive which are
What do you want in this? Why are you multiplying it, sir? You are appearing in all matters.
this is
You are going to frustrate the entire process.
Lordship,
You varied prayers you have sought for, compensation you have sought for, rehabilitation you have sought for, jobs you have sought for. So many reliefs are there. You are just enclosing some
Lordship,
court
this is-
order. Court order.
that is the order for the how the booths should be
Sir,
protected.
the larger issue is if you multiply it,
Lordship, kindly
we
see the
we
video.
will just admit it and
Lordship,
say,
kindly see the video once, Lordship, for my satisfaction. Lordship, if it is the condition of a woman, kindly see once, Lordship.
the relief sought for in the present writ petition tantamounts to multiplying
Lordship, this is different by different person on a different issue, Lordship.
the larger issue, which is already
Lordship,
seized off by the court.
kindly see, Lordship, this is the
It will
video.
be well open to the petitioner to intervene in the pending writ petitions, wherein the larger issue with regard to the violence and other illegal activities which were alleged to have which are alleged to have taken place during the Panchayat election. With the above said observation, the writ petition is
Lordship,
disposed
kindly
of.
allow me to file this because yesterday your Lordship has closed the door for that.
That's it.
May I file it there?
Come on 14th, sir. Next.
But Lordship, one thing, Lordship, this is the situation.
Yes,
Why I
yes.
have separately filed
yes,
this
yes.
because of the
Or
dignity of the
we can do one thing, we can release the matter.
Lordship, that
Yes, next, all that extension.
Serial number 14.
Lord, I am for the petitioner, my lord, in this matter.
My lord, I appear for the oil company, my lord.
In that matter, my lord, sister and brother.
What happened?
What
My
happened,
lord.
lord, in this matter, my lord, your lordship refused to pass any interim order. Rather, my lord, packet the interim order. We went before the Honorable Supreme Court. The Honorable Supreme Court passed an interim order till tomorrow.
No, my lord, there is some development in between also. My lord, they approached the Honorable Supreme Court.
And the
Now-
matter is pending in.
No, they, Supreme Court has disposed of them.
Kindly take up, my lord, application 2, can number, all orders are annexed.
No, what is the, show us the order of the Supreme.
My lord, I am handing over to you.
My lord, only Supreme
My lord,
Court
what had
modified the
happened-
interim order.
Wait, sir. wait.
8 minutes.
My lord, they approached the Supreme Court, my lord, couldn't, at the initial stage, get an interim order. They had moved another application before this honorable court. This honorable court was pleased to pass an order. ওই অর্ডারটা দেখি ওই
14, the order is there. Order. My lord, order is.
My lord, lordship will kindly take the order.
Read, sir, let us read.
This is my application.
আমার এই application দেয়নি।
All affidavit has been exchanged in the meantime. Matter is ready for hearing.
So we have to hear the appeal.
My lord, may I submit one thing? My lord, the subsequent pursuant to your lordship directions, the authority concerned suspended the, my lord, the.
We will hear the appeal.
No,
sir.
I have charged, that is the separate cause of action. I file a separate writ petition.
That has been revoked. That
My
has
lord,
already
no,
been
that writ petition, my learned senior pen in appear. And my lord is that.
No, he is going to, they are going to argue Mac 1000 of 23.
Lordship will give it next Wednesday.
No,
my lord.
we'll hear it now.
Hearing now, yes, grateful to lordship.
We'll hear it now.
As
We'll
well
come back 10 minutes.
Grateful to lordship.
My lord, affidavit is ready. My lord, it couldn't be filed.
We don't know. As per the direction of Supreme Court, we have to hear.
Grateful to lordship.
We'll hear. Whatever affidavit you are, it's up to you.
My lord.
দাদা
কপি দিন কোথায় দিলেন দুটো কপি
Yes, sir.
may we file our affidavit in opposition? I'm filing my reply. Or reply. Maybe.
Yes.
Before Lordship going into the merit of the case, I shall rely upon two orders passed by one by your Lordships and other by the learned single judge. Your Lordship, kindly take up the order dated 15th of June 2023.
Yes. Now we are hearing the appeal.
Yes, but why I'm saying so, my lord? Just give me 2 minutes.
No.
But your Lordship passed on 15th June order on the basis of the submission argued by my learned friends that this is a reserved category vacancy.
Correct. That was their submission.
Kindly see the order. Unmarried graduate woman. My lord, this is admittedly not. This is reserved for only graduate. There is no dispute about the same. Possibly your Lordship may not have passed this order. Your Lordship has been persuaded by my learned friend appearing for the private respondent and supported by the oil company. But if your Lordship kindly take up the opposition filed by the private respondent, they have annexed the document.
All right, we'll keep this in mind.
My lord.
Please proceed on the merits of
Yes, and another thing is that the learned single judge has proceeded that according to the marketing discipline guideline, all the partners have to sign. But this is also not correct because my lord, marketing discipline.
No, what you can do is, sir, you can formulate your points 1, 2, 3, 4. Based on that, you make your submission.
My lord. Yeah, just first, your Lordship kindly take up the order impugn of the learned single judge.
Yes.
My lord, at page 151 of my stay application.
Yes.
Page 151. You'll have to kindly turn up to the page 152. That portion has been recorded. First paragraph. The marketing discipline guideline governing the oil company requires signature of all the existing licenses for renewal of the distributorship. This is evidently not possible since to answer. This is not correct. Marketing discipline guideline I can place before your Lordship. There is no such provision that all the partners have to sign. I am not out to, just now I'm not making this submission, but this is the learned single judge proceeded with. But what happened in this case, my lord? On 5th of June 1992.
Yes.
An agreement has been executed amongst all the partners. Kindly turn up to at page, my lord, 50. This is an agreement executed 50 by and between the oil company and all the partners.
Yes.
Well, kindly see there are signatures, everything is there. If you should kindly come to clause 21 of that agreement at page 57. This is the main basis of the case of the oil company, page 57. Well, I'm reading, the distributor shall not sell, assign, mortgage, or part with or otherwise transfer the interest in the distributorship or the right, interest, or benefit conferred on him by this agreement to any person. In the event of the distributor being a partnership firm, any change in the constitution of the firm, whereby the retirement, introduction of a new partner is otherwise, however, will not be permitted without the previous written approval of the corporation. But this is the case made out by the oil company. According to them, if there is a reconstitution, prior approval is mandatory. So far, this reconstitution, which I am going to show people lordship, there is no such approval has been obtained. My specific case is that there is a change of share of profit amongst the existing partners. There is no inclusion, there is no exclusion. So this is not at all a reconstitution. Change of share of profit amongst the existing partners is not required to be obtained any prior approval.
Yes.
Now, Your Lordship, kindly come to page 69. A supplementary partnership deed has been registered amongst all the partners. After the marriage of my sister, he left his entire share, but keeping only 1%. Page my lord, 69. This is a registered partnership deed executed on 15th of September 1993. This supplement deed of partnership executed by Rina Dotto, so-and-so, by Manohar Dotto and my lord, another partner. Kindly turn up to my lord, next page, page 71.
Yes.
Page 71, I'm reading my lord, paragraph 2. Now, sentence start now. Now, as the partners Rina Dotto has been married and is living happily at her matrimonial home and will not be able to do any act of a partner, she has actually surrendered her 51% of share out of her total 52% in the business to the other partners, Manmohan Dotto, on consideration of his managing the business for whole time and for rendering constant labor for business, and henceforth on the above consideration, Manmohan Dotto will be hold 75% of share business, Bhutnath Dotto 24% and Rina Dotto 1%. That at the partner, Rina Dotto will be absent from the place of business. The business will be entirely managed by the partners of the second part, that is Manmohan Dotto and Bhutnath Dotto, and partners Rina will not be responsible for any act or omission or commission of the business. Well, this agreement has been signed by all the partners. There is no dispute. Kindly see, my lord, this has been, my lord, signed also by the father. He was one of the witness in this registered deed of partnership, supplement deed of partnership. Then, my lord, if lordship, kindly turn up to next page, page 75. My lord,
This is agreement dated 5th June.
my lord, 15th of September 1993. Left-hand side top, page 69. Signature, page 69, my lord, handwriting, the signature of the register, page 69. 15th September, the supplementary partnership deed.
No, you said 75,
No, page 75 is the new agreement. Sorry, my lord. I have shown people lordship the supplementary partnership deed.
69.
My lord, this is 5th of June 2002. Second line, memorandum of agreement made on September 5th day of June 2002. Have you also got first line, page 75? First line, page 75. But after execution of the supplementary partnership deed, new agreement has been executed by and between the petitioners, the private respondent and the oil company on 5th of January 2002. I have shown to your lordship, my lord, supplementary deed executed in 1993. After near about 10 years, after expiry of 15 years from the date of first agreement, according to the policy decision, policy guideline, this has been executed amongst by and between all the partners and the oil company on 5th of January 2002. Left-hand side bottom, kindly see signature of all the partners. And there is also same clause 21 at page 82. At page 82. Same clause. Reconstitution of the partnership deed by way of exclusion and inclusion. Then your lordship kindly come to page 90. Well, page 90 and extension, 18th of August 2007. Every alternative 5 years, thrice it has been extended. After execution of the supplementary deed, first my lord agreement for 5 years, then another one term 5 years, then another one term 5 years, and then last term 5 years. That is page 91st, 5 years. Page 91 is the next one, dated 4th of June 2012 for another 5 years.
Yes.
Then page 92, kindly see the last extension, 25th of July 2017 up to 4th of June 2017.
Yes.
But during this period, no complaint, no allegation, nothing. In the year 2010, private respondent
2010
refused to signature the licenses. Your lordship knows for running LPG distributorship, there are a number of statutory licenses. This is file license, NOCs. These are required. She refused to sign any of the licenses.
Yes.
But for that, we have to come before this honorable court, and matter went up to the division bench. Kindly turn up to page 93. This is an order of 1st March 2010, passed by the honorable division bench.
Page 110.
Page 93.
90.
Page 93.
Yes.
Kindly turn up to page 94, second paragraph. Mr. Swanso, learned counsel appearing for the writ petitioner appellants, submitted that the writ petitioner appellants are agreeable to furnish the documents as per the checklist in respect of 99% of the shareholding of the partnership firm, excepting 1% share, which is held by one of their relatives. Well, after supplementary partnership. It is further pointed out that the learned trial court in the impugned order of officers recorded that there is no illegality in issuing the said order, asking for those documents. Learned counsel has also relied upon Swanso plus 3/4 of the West Bengal Swanso. Then you should kindly come to the operative portion at page 96.
Yes.
However, we direct the appellant writ petitioner, that is my client, to furnish the documents as per the checklist, which has been annexed to the stay application at page 84 in respect of 99% shareholding in the state partnership firm. And after receiving the same, the respondent authority shall take necessary steps in the matter in accordance with the provisions of law for renewal of such licenses in favor of the partnership firm Messrs. Burma Gas Service. But pausing for a moment. But this order has been passed. Following these orders, explosive license, fire license, NOCs, all have been renewed.
Yes.
And I have placed those renewal license before the oil company. And unless I place this, my agreement or renewal shall not be done. The oil company is saying today, I have no knowledge. Unless I produced all those documents, they have acted upon all those documents. They have renewed the license time to time, allowed me to continue the business on the basis of the licenses issued by other statutory authorities in respect of my fire license, explosive license, NOCs. Never raised any objection.
Yes.
Then dispute again arose. The private respondent started disturbing with the business. We have to go before the civil court. Your Lordship, kindly turn up to page 106. elaborately considered all points, including the points of maintainability of the suit. Then the learned civil judge passed an order on 20th of March 2019. Your Lordship may read the first, second, third paragraph. All facts have been stated. So far, the supplementary partnership did.
An injunction was granted.
Yes, injunction has been granted. If Your Lordship kindly turn up to at page operative portion at page 107, 113. Sorry, my lord.
Interfering with the management of the suit
I'm
firm, as mentioned in the schedule.
My learned firm client has been restrained to interfere with my business. But this order has been challenged by the private respondent. Kindly come to my lord. No, they have challenged it before this Hon'ble court. No interim order has been passed. The matter is still pending for consideration. And so far our interim order is concerned, that is still continuing. So far this civil case is concerned.
Now revision application is pending.
It's pending.
What is the number, CR?
That I can give to Your Lordship, my lord. That they have
All right.
stated in our
It
application.
doesn't matter.
That is still pending. There is no dispute about the same. They have not proceeded with the same, and no interim order has ever been granted.
Page 120 perhaps is one of
120.
perhaps.
Whatever. My lord, sorry, my lord, page 120. I'm grateful to my learned friend also.
Hmm.
19th of January 2022. No, thereafter no steps have been taken.
No interim order.
No. Then Your Lordship kindly come the impugn order at page 143. First, my lord, page 142. Two partners have been intimated. Kindly turn up to page 142, 143, second paragraph. The distributorship agreement is still pending for renewal, as all the three partners are not coming forward together for signing of the agreement, in spite of several reminders in the matter. You are once again advised to visit Territory Office, Uliberia LPG Bottling Plant, Bishnupur, Howrah, along with both the partners, Srimati Rina Dotto and Sri Bhutnath Dotto, before 12th of October 2022, with necessary documents for renewal of distributorship agreement, failing which we will be constrained to suspend supplies of your distributorship. But this is one of the brother, and the next page is the other brother. So not challenging these two orders, we came before this Hon'ble court.
Now the one clarification. The last extension was up to 4th of June 2017. And subsequently
5 years.
5 years.
Yes.
Thereafter, it was not renewed the matter, but still business was going on.
Oil company wrote letter, numbers of letter to come and settle the issue.
They did
And
not.
according to me, due to the non-cooperation on the part of the private respondent, that cannot be.
But business was supplies were.
There is no dispute about the same. All together.
So from 2017, that is 5th of June 2017, business was going on.
Yes. Business was going on from 1992.
No.
But absolutely. I understand.
Lord, it will be 4622. In 17, there was another extension, which was till June 2022.
Oh, that's what.
Yes.
Last, where is that extension order?
Last.
It is there.
No, page 90 was the agreement. The extension has to up to 4/6/2017. Thereafter.
Page 92. Page 92.
Page 92. The facts.
Five years from 4th of June 2017.
Page 93.
The third extension.
Since
So till 3rd of June 2022, the agreement was extended.
no, that is because it was pending renewal.
No, we will not.
No, they moved the honorable single bench of this honorable court during Puja vacation, got an interim order, and that interim order
Okay.
is being
We
extended.
are only on facts.
Not from our side, my lord. It was by virtue of court order we are.
You implemented the court order.
Yes, of course, man.
So the fact remains that up to 3/6/2022, you had a valid agreement.
Valid. And thereafter, in terms of the court order, we are continuing till today. Now, the first question, if you also can go through the first order passed by the learned single judge at page 146.
Yes. So suspension kept in abeyance till 25th, 1st of October.
My lord. The time to time, learned single judge has extended the interim order and ultimately the order improved. I have shown to your lordship. So, my lord, varies.
Yes.
But the short question involved this matter, my lord, whether this supplementary partnership deed, registered supplementary partnership deed, which has been executed amongst all the partners for change of share of profit only, can be considered as a
Reconstitution. Whether it will fall within clause 21.
clause 21. If not, I think, my lord, there is no case on behalf of the oil company. And so far, the demand of the private respondent
That is supplementary partnership executed in 1993.
my lord.
Yes.
According to my understanding, this is not at all a reconstitution. No prior permission is required. And that too, they have proceeded, they have acted upon so far this supplementary partnership deed is concerned. Because they are very much aware that unless I produce the licenses, that is, my lord, fire license, explosive license, NOCs, I am not entitled to get any renewal. But these all renewals have been granted in terms of an order of the Honorable Division Bench. This Division Bench order has never been challenged by any of the parties. Admittedly, oil company was not a party in that proceedings, but they knows that there is an order of the Honorable Division Bench, and on the basis of that Honorable Division Bench order, as statutory authorities extending my licenses each and every year, and they have acted upon by way of renewing my agreement.
Yes.
And so far the private respondent is concerned, there is a still exist an interim order passed by the civil court, not to interfere with the business.
Yes.
Well, unless these two orders passed by the appropriate court of law is interfered with by any higher authority or higher forum, according to my understanding, so far the oil company is concerned, they have restrained by the Division Bench order. So far the private respondent is concerned, he has been restrained by the order of the civil court. Today, my lord, there is no question of emotion or something else. The Article 14 says everybody should be looked into equally. Whether she is lady or I am gentleman, possibly, my lord, this is not the questions. This is Article 14. For race, caste, it can be treated differently. The learned single judge proceeded on the basis of recording is also there that I am depriving my wife, sister. So far the facts is concerned, I have annexed the documents. I can show to your lordship also that income tax, but I am not going to see. Her income is much more than, but I am not on that. I have annexed the documents of the income tax return also of my sister. But one document I shall show to your lordship. If your lordship kindly take up the opposition filed by the private respondent in response to my stay application. There are two opposition, one by supplementary.
Yes.
And another by to the stay application. Just hand over to you. This has been affirmed.
That is by the 9th respondent.
9th respondent, 26th of April 2023. Affirmed.
5th of June.
No, this is 24th day of April.
You want the supplementary affidavit?
This is affidavit.
One is affidavit of 9th respondent to the appeal.
There are three affidavits filed by them. This is an affidavit.
Affirmed on 5th June 2023.
Kindly take up on the 26th of April 2023. Acha tha, yeah. 26th April. There possibly this is the first one. This one. There are three affidavits used by the private respondents. File করেছিস? May I hand over a additional copy?
Extra copy is there, please give.
It's just one document from this appeal. There is some ink mark. I have used it. Your Lordship kindly ignore it. But this is a Bengali document, page 23. Advertisement. Mr. Bhattacharya may go through the same. This is the first advertisement.
See, this is one affidavit is there. Which is the page number of the document?
23. This is a Bengali document. This is the first advertisement disclosing the conditions.
23 is there. See, actually, the date on
5th of June.
It
Yes.
is affirmed on 5th of June. There are only two affidavits, one affidavit of R9 and one supplement. Yes.
But it's a Bengali document. It's an advertisement, first advertisement. Your Lordship, kindly see. Justice Bhattacharya can read, my lord. Go. Have your Lordship got, my lord? কোনো বিশ্ববিদ্যালয়ের যে কোনো ডিসিপ্লিনের অন্তর গ্রাজুয়েট স্বীকৃত সমতুল। Then top portion, ভারত পেট্রোলিয়াম অপারেশন লিমিটেড এখানে ভারত গ্যাসের জন্য বেকার গ্রাজুয়েট, বেকার ইঞ্জিনিয়ারিং গ্রাজুয়েট। So only unemployed graduate. The submission before your Lordship that this vacancy was reserved for women category graduate, unmarried. Only graduate.
Unemployed engineering graduate.
Yes. No, my lord, kindly see the go. Kono বিশ্ববিদ্যালয়ের যে কোনো ডিসিপ্লিন। Have you Lordship Bhattacharya? Any.
Not engineering.
Law says any, but the top says only engineering graduate.
Bekar graduate within invert comma
That is
bekar
including-
engineering graduate.
That is including
Yes.
engineering graduate.
Any graduate including.
But my learned son kindly is a mayor graduate. But it says, my lord, the go যে কোনো বিশ্ববিদ্যালয়ের যে কোনো ডিসিপ্লিন অন্তত গ্রাজুয়েট। And the first line says ভারত গ্যাসের জন্য।
But both the brothers were not graduates. Only the sister was the graduate.
My client is also graduate.
Yes. Both the brothers are graduates.
Yes. One is graduate, another I have some doubt. One is graduate. One is graduate, as I understood. Another I cannot manage, just possibly, my lord, but just now.
All right.
But again, I am submitting before Lordship so far this issue is concerned. These are required for the reconstitution.
You saw that. He was the appeal. On what date that LOA was issued, letter of approval? Page number?
Letter of intent.
Please tell the page number.
Just that I have not annexed.
My lord, the first agreement with the lady is
Still, please answer our question. Letter of approval should have been granted.
my lord, 23rd February 1989 is the date of the first agreement is the
Page,
document.
page.
My lord, page 40 of my affidavit, my lord. LOA টা চাইছেন জজ সাহেব আপনারা ফুল বললে 17 page 17 sorry my lord oh sorry my lord page 17 my lord lordship page 17 of my affidavit my lord it's with the lady my lord dated 23rd February 1989 page 17 23rd February 1989 as a proprietorship.
So initially as a proprietorship, because she was inducted as a partner only on 26th, I mean, approved as a partner.
23rd February 1989.
No, the two people, Manmohan Datta and so-and-so Datta, were approved to be included as a partners by the BPCL on 26th May 1992.
Yes.
So the first agreement was with the 9th respondent as an individual.
Yes.
My lord.
She alone has signed, Miss Reena Datta.
My lord.
কি হবে এটা বলে আপনার
Then page 50 is the introduction of the partnership.
So therefore, the application was made in the name of Reena Datta, not in the name of the brothers.
At the first instance.
Yes,
Absolutely,
yes.
absolutely.
So whether you are a graduate or engineering graduate,
Immaterial.
Immaterial.
Immaterial. I'm grateful, Raj. Immaterial. And they have accepted the same.
That is correct.
1992, Reena made an application for incorporation the name of two brothers.
Correct, correct.
That has been approved and subsequently in the format of the oil company agreement has been executed. So far my eligibility is concerned, they were never questioned. And there is no question also.
No, they approved it in 1992.
Yes.
Thereafter, successive
Renewal,
renewals.
agreement, everything. And according to me, my lord, on the basis of the supplementary partnership deed, which has been executed by and between all the partners, that has been also accepted by the oil company by a subsequent 3 renewals.
No, is there any document to show that the supplementary partnership deed was entered into with the consent of BPCL?
No need.
No, because if you go to the original deed of partnership dated 5th June 1992, in page number 25 of affidavit in opposition of R9.
Page 25.
Let us, for some example, page 28, clause number 2. on clause number 1, business of the firm shall purchase LPG and so on.
My lord, this is of affidavit filed by.
For 9th respondent. Just we are referring to that.
Just a minute. Page কত বলে দর্শক? 29.
Page 28.
Page 28, clause 2. And lordship.
No changes in the constitution of the partnership deed made either by inducting a new partner or allowing to retire. My lord, this is my case. This is also clause 21.
No. So therefore, consciously all three parties agreed that nothing without the formal approval of BPCL can be done. But your case is change or reorganization in the share does not amount to reconstitution. So now let us go back to clause 21 once again.
My lord, but before that, one submission. My learned friend representing my private respondent also never approached the oil company. That approval is required.
27.
Lordship is looking at the supplementary, my lord.
So it is a reconstitution. So she
Other side.
reconstitution. It's a reconstitution. Clause 21 says otherwise. Control was. See, it uses the word otherwise. You shall not sell assets also. There's also partnership change in constitution either by introduction of new parties or otherwise. Whosoever will not be permitted without. Yes.
So my lord, clause number 2, 3, and 4 of page 28 entirely support my case. It says retirement, addition, inclusion, and exclusion. Prior permission is required. My sister also proceeded on the basis of this agreement. At the time of inclusion of her names, she sought for an approval at the first time. Next time, when there is a supplementary partnership deed, she also never prayed for the oil company that we are supplementing our partnership deed. So this approval is required. Kindly consider. This is 1992.
No, the supplementary deed was not placed before the corporation.
Neither by me nor by my lord.
Correct.
That what I want to say.
Due to the division bench directed based on the documents to support 99%, you please consider and do it. Renewals granted. So based on those renewal of license. So the supplementary partnership deed which was entered in the year 1993 was never submitted to the corporation either by the appellants or by the 9th respondent. So,
and my respectful submission before lordship. But unless there is again I am repeating my submission.
Yes.
This is not at all a reconstitution.
Correct. That we are
change of share of profit amongst the existing partners. So clause 2, 3, 4, which has been dictated in the first agreement, never support the case of the oil company that you have to obtain a prior approval in respect of change of share of profit. When it was required, approval has been obtained at the time of first inclusion of partners.
But at the time when the first deed was executed
amongst the partners.
in the year 1992, she withdrew for 48% of her share. Capital, sorry. Of her 48% of the capital she withdrew. Probably the brothers infused that capital.
Yes.
52% she retained. Still she enjoyed majority. Yes.
No.
Page 27.
Absolutely.
Whereas the partner of the first part, Miss Reena Datta, has withdrawn her 48% capital from the firm, namely so-and-so gas service, keeping her 52% capital in the firm, and to run the said business smoothly, the incoming partners of second part and the partners of so-and-so have agreed among themselves to do the business named so-and-so, that the partners jointly may determine in running the said business in partnership under the name and style Burma Gas Service. Now, therefore, the first and so-and-so are mutually agreed themselves. So this document was approved. This document was approved, and in page this document was approved on 26th May 1992, and those two partners, the brothers, were permitted to bring. But the thing is, 48% of the capital was withdrawn, but still she had 52%. The dealership was originally granted in the individual name, and that was going on, and then this brothers were inducted. Subsequently, she withdrew
51%.
51%
out of 52.
So she becomes a minority shareholder, and she loses control over the business. And one of the brothers gets full control.
Yes, that's the
This document was without the approval of the corporation.
subject to lordship.
And your contention we have noted.
Subject to lordship consideration. Your lordship once again kindly turn up to the supplementary partnership deed, just for my satisfaction.
Yes.
At page, my lord, it starts from page 65. It starts from 65. Kindly turn up to 69.
Page 69.
Recital, then kindly turn up to page 71.
Yes.
Page 71, just 3 paragraphs I am reading, my lord. Whereas now, after change of various circumstances of the parties, especially of the partner, Reena Dotto, who has been since married, some of the terms of the previous partnership are now changed for the benefit of all concurred in this manner in subconse below. That except the terms and expressly provided in this deed, all other terms and original shall be prevailable between the sponsors. So, my lord, except whatever has been stated subsequent thereto, all existing will continue. Then, my lord, now the partner Reena Dotto has been married and is living happily at her matrimonial home and will not be able to do any act of a partner. She has mutually surrendered her 51% share out of her total 52% in the business to the other partners, mutually. Monmohan Dotto, on consideration of his managing the business for whole time and for rendering constant labor for the business, and henceforth on the above consideration, Monmohan Dotto will hold 70% share business, Bhutnath Dotto 20%, so and so. That as the partner Reena Dotto be absent from the place of business, the business will be entirely managed by the partners of Bhutnath Dotto, so and so. But pausing for a moment, just what I want to submit. But this has never been approval has been obtained. But when the division bench directed, kindly consider,
Division bench is on a different aspect, sir. Division bench, BPCL was not a party to that.
Absolutely.
He was in it.
Absolutely.
The fact remains, now the test is, who is the dealer? The reader was the ninth respondent. After the ninth respondent was operating, there was a document which was created in the year 1993.
Yes.
No, June, 5th June.
1992. 15th of September 1993. But this is page 69, left hand side. Page 69.
Yes.
Registered supplementary.
No. The earlier, first time, in fact, it was a sole licensee.
Absolutely.
This
Proprietorship.
ninth respondent was
Proprietorship.
Proprietorship. Then she thought fit to induct two of her brothers. So a partnership deed was drawn. That document, in that document, what she says is, I will take back 48% of my capital. Out of 100% capital, I will take back 48. I will retain 52. That agreement was approved. But that agreement says in several places, anything can be done with the approval of the BPCL. Right?
Not anything.
All right. Reconstitution.
I have some allergies so far this anything.
Correct.
Yes.
Reconstitution can be done only with the BPCL. If there's a dispute also to be referred to the divisional manager of BPCL for arbitration. No problem. Probably what would have made the mind of BPCL is, yet my licensee or my agreement holder holds 52%. So she has control over the business. What she did thereafter? 51% she released. She took back 51%. She lost control. The dealership is gone.
Is there any such shoppers? Is there any? No.
No.
Subject to lordship consideration. Subject to lordship consideration. I have never been intimated, even after their knowledge, that this granting of leaving outside 51% in favor of our brothers is not permissible. There is no show cause, nothing.
We will only consider the legal issue, whether by virtue of this arrangement, 51% she has taken back, 1% she has retained, whether that tantamounts to, or whether it will fall foul of
21.
That's the only.
Whether 21
and
is
we will
change of share come within the purview of clause 21.
That's all.
So we can go clause 21 once again. What will that would be paper?
That's the only legal issue. Coupled to the fact, coupled to the fact that 234, but coupled to the fact that you got an order of injunction restraining her. Number 2, division bench order. Number 3, licenses were renewed based on the division bench order, which records that you are 99% shareholder plus 3 renewals.
Then just clause 21, I shall conclude my submission. Page 57.
Yes.
May I read, my lord?
Please, sir.
The distributor shall not sell, assign, mortgage, or part with or otherwise transfer his interest in the distributorship or the right, interest, or benefit conferred on him by this agreement to any person in the event of the distributor. Pausing for a moment.
Yes.
Just 3 lines. So far, her granting of 51%, there was no dispute. So these 3 lines does not say you cannot give any person to anybody. Again, I am repeating, my lord. First 3 lines says,
according to you, it is does not amount to selling or assigning or mortgaging or part of parting with or
as far
otherwise.
as been interest. She has done it. She has done it and that has been accepted. So far the first agreement is concerned.
Correct.
Am I
48%?
Whatever may be. So losing of interest of the business and granting it to somebody else is not a clause for termination.
No, there is no issues at all. Their issue itself is this 51% are taking back.
I'm not.
Is not approved.
If my lord, these 3 lines allow the existing proprietor to transfer his any percent of share is permissible, then entire class 21 written is in my favor.
No, shall not sell, etc., transfer in the distribution, right, so and so. Next sentence has to be read along.
The event of the distributor being a partnership firm, we are following this. Second part. Any change in the constitution of the firm, whether by retirement, introduction of new partner, or otherwise, however, will not be permitted without the previous written approval of the corporation, notwithstanding that the corporation may have dealing with such reconstitution firms as impliedly waived or conducted the breach of any benefit mentioned hereafter so and so.
So there is no, you're right in your submission. There is no right, absolute bar in transfer, assigning, mortgaging, or
Losing interest.
Whatever it is.
Yes.
Transfer is interest. What is her interest? She held 52% share. That interest she can transfer. There's no bar. Only rider is without the prior written approval of the corporation, it cannot be.
Reconstitution.
Reconstitution.
Mali kindly consider.
Change in
excluding and including retirement or inclusion per approval.
Or otherwise.
Unless there is a retirement, inclusion, unless there is a
So your argument is this will not fall foul of clause.
absolutely not. This is not reconstitution.
We will hear the respondents. 2:30 we have got one matter. After that we will continue.
After 2:30 matter.
That's an admission matter. I don't know how much time it will take. Let us see.
Allot, we will finish off.
Finish it brief.
Yes,
sir.
Don't take much.
Facts are clear.
We have heard about fell from your lordship, my lord.
Facts are very clear. We have gone through the agreement. Don't repeat. First we will hear BPCL and then we will hear.
Lordship.
Like item number 15, my lord, is also extension of interim order. The appeal is admitted.
After 2:30, after 2:30 matter also.
Division. Here is the last stage. So I was visiting your lordship.
Respondent.
We have also mentioned we will notice that we will mention.
You come back at 2:30.
My lord, may I pray for one indulgence, my lord? This is not the time of mentioning, my lord. My lord, under a very compelling circumstances, I am troubling your lordship, my lord. In regard to my lord, item number 112 of my lord, your lordship's lease dated, my lord, 20th of this month, my lord. My lord, in this
What happened?
My lord, in this matter, my lord, your lordship passed an order out of turn that, my lord, that ECL authority, my lord, they are taking steps, my lord, despite of, my lord, they have given an undertaking before your lordship. And now, my lord, the matter is appearing before your lordship's list, my lord, is a group 9 appeal, my lord, under the heading, my lord, adjourn motor. My lord, the appeal has not yet been admitted. This is my lord, this first point. And subsequently, my lord, now, my lord, the appellant is, my lord, going to face the worst consequence, my lord, the same area, my lord, on which that in which tender, my lord, the appellant participated, my lord, they have again, my lord, taken a step, my lord, they have published a tender, my lord, in respect of the same area, my lord. If your lordship kindly, my lord, if your lordship kindly fix the matter, my lord, at your lordship's
You mentioned in their presence.
Permitted to mention item number 12 of today's list. I'm for the petitioner lordship. When the matter was called, I was busy in court 10 and the lordship was pleased to dismiss the matter for non-prosecution. I'm praying my humble prayer is that the matter be restored, lordship.
My lord, I have already served notice to my other side, my lord. He is also consented, my lord. If your lordship kindly fix the matter, my lord,
Sorry.
mail. Now, my lord, this is the last order whereby the appeal was admitted and my lord, an arrangement was made.
No, interim order is in force still.
Today.
What is the nature of interim order?
Nature, my lord, by this is my lord, in the writ petition, we have challenged that the adjudicating authority formed under the PMLA has not been formed properly. We have taken the point of quorum non juris, and my lord, at interim stage only, my lord, my writ petition was dismissed, and thereafter we preferred the appeal. Now, my lord, there was urgency. We moved the matter on 13 July 2023. Lordship sees the appeal is formally admitted, and case of myself and also of the Union of India has been recorded here. And thereafter, well, let's see the second paragraph. The enforcement director takes a very fair stand in the matter. He submits that he would ask his client.
No, this is not an interim order.
Correct. Well, an arrangement.
No, yeah, arrangement should be. We will hear the other side. He is not here.
Well, I have.
You please wait. We have got a 2:30 fixed matter.
Lordship.
We'll take up that matter. You please wait. So the morning you made a representation. It's an.
Well, I said, well, today now said, well, there is an arrangement which is there.
No. What we heard or what little English we know, we heard it as there being an interim order.
Lordship. So
you please wait. It's a concession granted. The court has not granted. Simply adjourn the matter.
So
be heard by them. Let us see whether he comes. Sir, please call the 2:30 matter, sir.
Lordship, may I permitted to mention one matter for leave, Lordship?
Nothing. This is not mentioning time.
Appellate side, daily listed matters fixed at 2:30, item number 1 and 2.
I appear for the appellants, I'm led by Mr. Salvi is appearing virtually.
Yes, sir.
I appear.
May please, my lord.
I am appearing for Restart Company.
You are for
Restart Company, ROC.
ROC, Restart. For
Reserve Bank of India.
Reserve Bank of India.
My lord, very broadly, if I may tell your lordships before your lordships open the file, how the matter arises.
Well, once again, sir, just adjust my screen. You can't tilt the screen. You can't tilt it. Yes, that's better. Can you push it a little this side? Yes. Yes, sir.
But the matter lies in a very narrow compass. If I may just tell your lordship what the matter is about.
Yeah.
My lord, this relates to the peerless company which used to collect deposits from people. They were regulated by the Reserve Bank. Reserve Bank made regulations. They were challenged, upheld by the Supreme Court. That's a while ago. And after which they were asked to wind down their business. They wound down their business. So that part is over. They had unclaimed deposits. And there are two competing legal regimes in play. One is the regulations made by the Reserve Bank, which governs the working of what are called the NBFCs, the non-banking financial companies.
Yes.
And there are the directions issued by the Reserve Bank for the non-banking financial companies. And under the Companies Act for general companies, which receive deposits, there are a set of regulations. This issue has come up, up to the Supreme Court, and in Supreme Court, Justice Ram Subramanian judgment, his lordship said from cradle to grave, you are governed by the Reserve Bank, as far as NBFCs are concerned. Now here, my lord, in 2007, RBI said, please stop accepting and collecting deposits. That was duly discontinued. 2011, it was all gone away. Then, my lord, for a while, the High Court stayed the rules, monies were collected. Today, controversy is very limited. There were uncollected deposits. We asked the Reserve Bank, what do? They said, first they said, keep it. Then they said, you give it to that fund under the Companies Act. So you may not be paid the principal amount. That money was kept in escrow for a while. Some interest accrued. We asked the Reserve Bank, what do we do with the interest? They said, interest is yours because you had not used the money, you had kept it in escrow, you may keep the money. Then, my lord, the registrar company said, no, you have to pay it under our regulations. So the neat question of law, whether those regulations will at all apply or whether it will not apply. We also, my lord, relied on two, what we say are statutory directives of the Reserve Bank, which expressly said what I'm saying, that you can keep the money, and I'll show those in a moment. The question arose, what is to happen. Reserve Bank said there is no, Reserve Bank's defense was there is no estoppel. That's not a question of estoppel. If you issue a direction under a rule, that direction binds unless the direction is, nobody is arguing the direction was ultra vires, the law which on its face can be ignored. So we have followed those two directions. The learned judge at one place says Companies Act will also apply notwithstanding the Supreme Court judgment. And at another place, he says these were just stray directions, stray or otherwise. It's a direction, it must bind. That's the inspectors of this appeal. No? If your lordship sees those two letters straight away. The first letter, my lord, is the letter of 31st October 2014 at page 106.
Compilation 1 to be handled.
I believe it's in compilation 1, which is just being made over to your lordships.
It's there in MAT 1250.
Yes, ma'am.
Page
106.
Convenience compile
106.
that only the relevant direction, because there are a lot of papers which may not.
Whether senior has got that convenience compilation.
I do, my lord. I do. It's page 106.
Has the convenience compilation. Lord.
Whichever you want us to refer, we'll refer.
106.
Page 4.
Wait. I believe it is running page 4 of the convenience compilation.
Okay.
There is a page 106 written on it, maybe from the original bundle.
Yes.
This is the letter of 31st October 2014. This is, my lord, an inspection report under 45N. Your lordship, I'll show the provisions that necessary. The RBI conducts inspections and other power to issue directions. Para 2 says in this connection, you're aware company was advised to repay all deposits by 15. The books of accounts reveal unclaimed deposits remain very high, 1,630 crores. You know the fact that company is required to repay all deposits less than 1 year, and also fact that unclaimed deposits are huge. You are advised to escrow the aggregate deposit liability at the earliest, not later than 3 months from the date of this letter. Accordingly, operational guidelines for opening and operating the escrow accounts are in Annexure 2.
Yes.
And then they say, please do it before the board of directors and make a compliance report. So, there can be no manner of doubt that this is a statutory directive. It is binding on us. We carried it out. Annexure 2, your lordship will find at page 7.
Yes.
Operational guidelines for operating escrow account shall be as under. Company shall keep the amount equivalent to the amount outstanding in public deposits with the present value of future interest differential to be calculated on return provided, etc., etc. In an escrow account in the FDRs of one of the scheduled banks that are unclaimed and not yet eligible for transfer to investor education fund, alternately invest the amount in government securities. Deposit the FDRs as the case may be. Please see small Roman 3, my lord. FDR securities can be withdrawn for repayment of public deposits on production of a certificate from the auditor. The amounts deposits are claimed. Now, clearly, my lord, therefore, this was binding on us. We fulfilled our obligations and we worked on this. This is, my lord, October 14. We wrote to the Reserve Bank, and that your lordship will find at page 8. Because we are asked to escrow, your lordship saw that a moment ago.
Yes.
Not just the deposit, but the present value of the future interest differential. So in one sense, the interest we had to put in the escrow. I'm sorry, my lord, I should have highlighted that at page 7.
Together with the present value of
the future interest differential to be calculated. So, my lord, if any interest to be paid, I have to put a principal amount so that whenever that depositor comes and claims, he gets it with the interest as on that date. So, my lord, we asked him, what do we do? Our letter was, what happens to the interest on this interest, in one sense, of interest on this amount? So, page 8, your lordship sees.
Yes.
Which first para says, Board of Directors in the meeting of 25th November has in principle agreed to escrow the aggregate deposit liability. Operational guidelines as Annexure 2 require certain clarifications. Then you say, what A, your lordship may ignore. See just below A.
Yes.
In fact, my lord, small Roman 2 of A, your lordship sees. deposits remaining outstanding less than 7 years together with the present value of future interest differential. You'll also buy that one.
Yes.
You are requested to advise whether the interest on the above FDR and escrow equivalent to the entire ALD will accrue to the company or not. If not, the tenure of the escrow account and the procedures to be followed on completion of such tenure. And then, my lord, we asked various questions. If you have to make the FDR for the escrow, we need to be divested before maturity, etc. How is the cutoff to be calculated? These are how to work out the details. So the Reserve Bank replies, my lord, on 3rd of February 15, and your lordship will find that at page 11.
Yes.
Para 2 says, clarifications raised in your letter are furnished. In the annex, the clarification may be read as a part of the letter of October, and the company is advised to escrow the aggregate deposit liability at the earliest, not later than 6th February. Now, my lord, please see page 12 onwards.
Directions in para 1.
I mean, it's not merely a matter of semantics. They call it directions. Now, if your lordship sees page 12 onwards at page 13.
Whether interest on the above.
Interest on the above FDR equivalent to the entire ALD would be accrued to the company, subject to the company maintaining amounts not less than the amount stated in A1 to 3 above in the escrow and producing a certificate from the auditor. So and so, any interest received by the company on investments and fixed deposits or government securities would be available to the company. Now, this is, my lord, what they have issued. I dare say, no, there's no question that this was a directive. And there are statutory provisions. The direct statutory provision, my lord, is 45K.
Page 20 of the compilation. The new letter also to the reiterate. Same compilation.
Yes, yes. Your lordship has, I'm sorry, I should have shown, my lord, in the same compilation. There is yet another letter from the Reserve Bank on 29th of June 2015. Page 20. But it just says you may receive the interest.
Compilation being handed over. Static compilation.
The company may receive the interest on investment.
Yes.
So on.
So we received the interest, we kept the interest. We accounted for it. It would go in your income and we treat it as part of the taxable income.
Yes, yes.
So, my lord, we have acted on it. Now, 45K, I believe there's a compilation which has been prepared to assist your lordship with these statutes.
And regulations, lordship, for my lord's convenience.
In this, if your lordship turns straight away to page 18, I don't need to go anywhere further.
Yes.
Power of the bank to collect information from non-banking institutions as to deposits and give directions. So, my lord, squarely covers institutions like us. The bank may at such time direct that every non-banking shall furnish to the bank intervals also statements, information with the deposits of non-banking institutions. Now look at, my lord, subsection 3. The bank may, if it considers necessary in the public interest, to give directions to non-banking institutions generally or to any non-banking institution or group of non-banking in particular in respect of any matter relating to or connected with the receipt of deposits, including the rates of interest payable and the periods for which this deposit. And my lord, subsection 4, if any non-banking institution fails to comply with so-and-so, banks may prohibit acceptance of the deposit. And this is all binding on us. Then, my lord, there is 45L, because these are overlapping provisions. 45, which I just showed, my lord, K, speaks of inspection, and your lordship recalls the October 14 letter spoke of an inspection carried out under 48N.
Yes. An inspection of the PRSO also.
Correct.
Under 48N from
Correct.
June to July.
Yeah, that's the provision, my lord. Your lordship doesn't have to read it because it's in plain language. It says bank may inspect any is at page 22 of this compilation. Please don't bother turning to it. So this is how it was done. And the bank issued these directives. There is also another provision, my lord, 45L, page 19 of this compilation. Don't mind.
Yes.
If the bank is satisfied for enabling to regulate the credit to its advantage necessary to do it may, small a b gives such institution generally any institution relating to conduct of business. So, my lord, I would rather go by 45K because it's there, but there are so many overlapping powers they have to give directions. Now, the point is nobody has challenged this direction.
Okay.
I accepted it, I acted upon it, and the Supreme Court has said from cradle to grave, we are governed by these. That is, my lord, 2022 7 Supreme Court cases, 394. I believe the judgment is being handed over to you, my lords. There, the question was whether the Kerala Money Lenders Act, Gujarat Money, the State Money Lenders Act would apply.
Lordship, may I just hand over the case instead of the compilations, my lord? I believe that will be. My lord,
But
may
just one judgment is required now.
just one judgment, Lordship. I'll just take that back.
I don't want to take more time today, my lord, just for admission. Just want to show my lord how the matter arises.
Yes, sir.
If your lordship turns straight away, my lord, to printed page 416. Question was whether the State Money Lenders Act have any role to play. And section 47, para 47 says one of the most important provisions contained in chapter 3B, 45Q. I showed my lord provisions from this chapter, my lord, with K and L and all this. 3B is as follows: with the provision of the chapter shall have effect notwithstanding anything inconsistent therein contained in any other law for the time being in force or any other instrument having effect. So, my lord, even the Companies Act stands overridden. Para 48 says, too long in the day to dispute the directions issued by RBI statutory in character and binding on all NBFCs. It is so in respect of all directions issued both under the RBI Act and the Banking Companies Regulation. Once it is found that 3B of the RBI Act provides a supervisory role for the RBI to oversee functioning from the time of their birth till of the registration till the time of their commercial death by way of winding up, all the activities of NBFCs automatically come under the scanner as a consequence. A single aspect taking care of the interest of borrowers, which is sought to be achieved by state enactment, gets subsumed in the provision of 3B. Then, my lord, para 58 of printed page 422 of this judgment.
Yes.
Para 58, my lord. It may be true RBI may not be controlling the rate of interest charged by NBFCs on loans. It does not mean that they have no power to step in. The power to determine policy issue directions available under 45J can always be invoked. However, it was contended by Mr. Gupta, Merit Council for Kerala, that the power of RBI under JA to determine policy are circumscribed by so and so, so and so. Para 60, but we do not think relating to appears can be taken to restrict the powers of given directions only in relation to matters relating to and items relating to, etc., etc. Look at para 62, Malad. In any case, 45L1B, I just shown Malad that provision, confers power on RBI to give directions to the NBFCs relating to the conduct. Therefore, to say that RBI has no power in respect of such an important aspect may not be correct. The fact that RBI leaves it to the market forces to determine the rate of interest without any direct intervention is not something that can be taken advantage of by state of Kerala to step in and prescribe the maximum rate of interest. So, Malad, this is virtually from birth to death, we are governed by the Reserve Bank. Now, Malad, the discussion before the learned single judge, just 2 or 3 paras, your lordship will say.
We'll hand over the compilation orders.
Not necessary. The 2 errors of law, Malad. The discussion begins from paragraph 50. First of all, in para 52, it is in the, I'm reading the impugned judgment, Malad, the judgment under appeal.
Just give us a minute, sir.
I'm so sorry.
I'll just take the memorandum. Paragraph 52.
Yes.
Yes.
However, the RBI as well as the IEPF, your lordship highlight one. Para 51 is our contention. These are directions. However, the RBI as well as the IPF dispute such proposition on the ground they cannot be estoppel against statute. Where the question of estoppel against statute? We are governed. That statute occupies the field. You issued, RBI has issued directions, and now the RBI says they cannot be estoppel against statute. How can they even be heard to argue this? Secondly, it has been brought to be made out that there is no inconsistency between 3B and 205C. They are forgetting it is not a do-don't inconsistency, it's a occupied field. In fact, that's why I read the paragraph to you, my lord. They said Reserve Bank has not prescribed rate of interest. The Supreme Court said, but they can. The point is, they occupy the field. Now, my lord, please turn to para 55. The learned judge accepts that if there is inconsistency, Chapter 3B would override the provision of the Companies Act. And then he finds that there is no inconsistency, which, my lord, is the wrong test to apply. Then, my lord, para 67 is the second major error of law. (66-67).
Yes.
As such, on a composite reading of 3B, none of the sections thereunder are seen to deal with the interest on the amounts deposited in the escrow provisions like nature by the principal of which liable under law to pay. Looking from such perspective, the communication which are relied on not directions within the contemplation of 3B at all. But without a challenge, the direction is set aside. And who says it is not? If it was challenged, the RBI should have defended their direction. An inspection report is called for. I showed my lord 45K. Under inspection, you can give such direction that you consider fit. RBI issues the directions and now disowning its own directions.
Three directions in 62.
In fact, my lord, in an earlier para 62, the learned judge says 45J, the general power to determine policy, the argument that the directions given with regard to availability of interest on escrow are covered by the section cannot be accepted simply because a straight direction cannot be elevated to the plane of a policy decision. But who says policy decision? Why it issues a direction is another matter. It's issued a direction. The union government has not challenged the direction. The Reserve Bank cannot challenge the direction. And we are saying it's perfectly valid.
But what was the cause of action for filing the writ petitions?
Well, the registrar company said, give us the interest. First, he said, give us the deposits. Then the RBI said, if we filed a writ petition, the courts passed an order saying, keep it in escrow. The RBI said, give them the deposit. We gave them the deposit. Then we asked the RBI, what did we do with the interest? They said, keep the interest. So I kept the interest. Now I'm being told this is not the RBI directive.
And
Now, Lord, I have taken this in my books. I've treated these as part of my income. I've paid taxes on these. Now, how do I turn the clock back?
and what was their answer about this income tax matter?
Nothing, Malad, nothing. They say this is a straight direction. And para 77, they say these were orders made under, deposits were made under orders of the court. That's correct, because originally when the registrar said deposit the money, I went to the court said put the money in escrow. The court did not give me a direction of what to do. Normally, Malad, if the court says put the money in escrow, I put the money in escrow. If I get the money back, I get the interest.
Court said first time, second time, RBI.
And based on that, the RBI then issued that direction. I showed my lot. The RBI direction was you pay the whole amount. So we have paid under the RBI and they said, tell your board to pass a resolution, give us the compliance. So all my writ petition, everything went down the tube. Everything is over. Because my lord, I can't fight it. If the RBI says you pay to, I am saying, Mr. Registrar, you can't ask me. RBI says you pay, because I am saying RBI is my governing authority. RBI says you pay him. It's the end of the matter. I asked the RBI, what do I do with the interest? They said, keep the interest.
Now, after the registrar says that, RBI has taken a different stand, is it?
Yeah, now the RBI is saying that there is no estoppel, there is no, this is a straight direction, this is not policy. It requires consideration. Let me hear it. I have time till 31st August. Whenever your lordship has time, your lordship can fix it and hear it. Or give me a short protection. Or give me a short protection, my lord, where the money is lying where it is.
Now the single bench has directed you to repatriate that interest component.
Yes. By 31st August, please extend that time by 2 months, 3 months, whenever your lordship can hear this matter.
What was the interim order during the pendency of the writ petitions?
4 interim orders.
My lord, there have been a series of interim orders. We were protected all through.
Can we just have a look at?
Yes, of course.
Compilation of orders.
I believe there is a compilation of orders which has been prepared.
These are all the orders which were passed in the impugned writ petitions and all the, including the orders by which we were protected.
The best order to be looked into, or which is the first?
Yes.
Page 3.
I don't have that. Yeah. Yes, I've got it. The earlier orders, my lord, your lordship will find.
I think the first order might contain some reasons.
Yes.
March 6th.
There is an order, which page number?
That's page 3 of the compilation.
If your lordship sees the compilation, right at the beginning, my lord, page, I believe it's at page 3.
From 2007, the matter is going on.
Yes. Page 7.
Yes. And in that page,
Because,
there is a direction.
Yes, my lord, the reasoning starts for the first page. Dispute regarding applicability of 205C with reference to the credit of matured deposit, so on, so is under challenge in this petition. Then my lord, he gives the all the reasons. And at the foot of page 9, this rider in my prima facie views, contrary to the provision of 45Q of the RBI Act, for the sake of convenience, 205 is set out. And finally, at page 12, the learned judge therefore says, considering submissions of counsel, the triable issue has been raised. Court is conscious of interim order staying the operation of show cause, etc., etc. And the court goes on and says, page 12 is the prima facie finding. On consideration, the court finds that the provision in 205 is inconsistent with 45. And on that basis, the court gave a protection.
And there is nothing about what will happen to the interest which accrues.
No, Lord, nothing. Your lordship can take it there. There were later interim orders when the interest demand came. We got to stay.
We'll hear the appeal sometime.
Yes, one at any day which is convenient. It's a very narrow point.
Extended, Mira. It's 31st August. It may be extended for 1 or 2 months. Let the appeal be heard day to day.
That's
no
better.
problem.
Whenever my lord fixes the date, subject to lord.
So far the interest is concerned, it is the question of 2003.
No, the problem is, as per what the learned senior counsel has pointed out, clarification was sought for. Reserve Bank of India
Yes,
is supposed to have clarified.
yes,
And the first direction issued was pursuant to an inspection under 45N.
that is correct. Yes.
Now, you will have to trace your power to say that that was not it was not a statutory direction. It is probably an advice or a letter simpliciter. That is one. Second is, more importantly, what senior counsel has said is, this monies have been brought into their books,
Yes.
expended for certain, whatever reasons they would have expended,
right.
and taxes have been paid. Now,
Yes.
how to get the clock back?
That's the company's problem, my lord. What we can do?
No, no, no.
Look, the interest, so far the interest is coming.
So therefore, you could have done some-
2003, my lord.
Sir,
They have
ROC.
deposited 1,500 crore at your lordship.
No, the first order.
2019, my lord, 2019, they have deposited 1,500 crores by the order of the court. Till the amount was there with them. And the interest is more than 500 crores, my lord. Now we are in 23. Let them, sir, calculate the interest. What is the amount of interest till date? Let them give us.
He says that interest is not available with me. The interest has already been expended. I've
That's
shown
right. I'll have to bring it from my pocket.
See, the argument itself is, I brought it into my books, treated
Yes.
income, interest income, used it, probably some deductions might have been claimed, etc. Taxes paid.
Yes.
The question is, sir, before RBI issued such directions, are they required to consult you? If the question is no, can you supersede or sit in judgment over the direction issued by them earlier? That
The
we have to-
interest amount they have spent, they have paid the taxes. This amount was not theirs. This
But-
interest is on 1,500 crores, my lord,
That's the
which is
interest rate.
ours, which is ours.
No.
They have not deposited. They have earned the interest amount on my amount. If they could have paid that.
Anyway, that's to be considered, my lord.
So, my lord, that is there.
My lord,
No.
may I? My lord, the question is, did they have a statutory liability to return this interest? That aspect has not been told to your lordships. Section 205C of the Companies Act 1956, also brought in the new act also, same provision. 205C, that, my lord, if your lordship takes that Companies Act 205 clause C, 205C,
Yes.
kindly take that.
And that is also under 25, under 213 Act, 125, my lord. It's all the same.
It's on page 2 of
205C.
My lord, I did not address your lordship at length. Our case is that section has no application.
Yes.
Now, my lord, let us come to this. 205C subsection 2, clause.
Sorry for interruption.
Yes.
But before that, should you not take a clear stand as to what is the purport of your communication?
Yes,
dated
my lord,
31st October?
I owe an.
That's the crucial
Yes,
issue.
that's it. Now, my lord, your lordships have seen that this 2007 interim order.
No, before that, sir. Actually, the petitioner.
No, my letter is after that. My RBI letter is after that.
True.
I have to explain, my lord, why I have said that the interest is available to you. I need to explain that.
That's it.
Exactly.
Because
Now-
this letter,
Yes.
no, if this is read in isolation, nobody can get a clue that it is pursuant to some, or there is a litigation in
There
the
are
background.
nobody, but not the parties. The parties who are aware of it,
They are aware of
they are aware of the situation under which this is given. Now, why RBI has written this? Because there was a list, a writ petition pending before this.
You could have taken leave of the court.
No, not that. I am not asking for anything else. Court has said, the court did not say anything about the interest to be deposited or paid by them. Court has simply said the principal amount then detected was 35.5 lakhs.
5 lakhs, first order.
Crores. That amount is to be escrowed. That was, therefore, there was no direction regarding refund of interest.
Nothing at all.
Therefore, naturally, my lord, RBI could not override the High Court order and say that you also deposit the interest. Therefore, RBI only said you escrow this amount as the
That's not true.
direction. So far as interest is concerned, my lord, that since there was no direction of the court, it says that it is available to you. Because at that point of time, it was the issue was not decided.
What was the clarify.
I'm so sorry to interrupt, my lord. It's really unfortunate RBI is saying this. The court said prima facie section 205 does not apply. Despite that, the RBI directed me to pay the entire money to the registrar, and I complied. It's not a question of overriding. I said RBI is the boss. RBI said, yes, I'm the boss. I'm asking you pay the fees. So that time they didn't find this contrary to the court order.
If at all the registrar of companies or the RBI had any doubt over the proceedings, and if you said that you are just asking them to comply with the interim order,
RBI was not
you
even,
you could have very well gone.
RBI was not even implemented as a respondent.
In joint data, I mean,
At a later stage, by way of addition,
When the parties.
long afterwards.
No, parties means RBI also. When you are aware of the order and you seek for and a clarification is sought for, nothing prevents you from saying that, sir, please get the clarification from the court.
Can the RBI letter be read contrary to a statutory provision?
Already, sir, we hear the matter.
The statute
from
is very much clear
2007.
that you have a duty to deposit. The statutory duty.
Registered under the Companies Act. The Companies Act apply to them. At 200.
No, it doesn't. We argue it doesn't. That has to be decided.
Yes, the amendment was in 99, where the Investor Education and Protection Fund was created.
Miller Supreme Court says that Chapter 3B of the Reserve Bank of India Act is a complete code. True. But then Miller, an NBFC is also guided by the provisions of the Companies Act in many respects, like holding AGM, getting incorporated.
What is it? Finance judgment has been pressed into service to say that you are supreme.
No,
that is
what
that's what the
says
senior
in the
counsel
context
argument is from birth to
yes, from cradle to the grave.
Cradle to
the grave.
cradle
Yes.
to the grave.
But in what context, Lord? This is in the context
No,
of
why are you giving up your power? This Supreme Court says you are omnipotent, omnipresent.
Omnipotent.
And what is the
Lord,
does the ROC do?
Omnipotent in the while the Supreme Court kindly see the
He's a procedural master.
Kindly see, my lord, the field in which this judgment is given. My lord, the Gujarat and the Kerala legislatures, they had made certain provisions, my lord, which are running contrary to this RBI Act, Chapter 3B.
That was subject matter challenge.
In that context,
the question of whether non-banking finance companies regulated by RBI in terms of Chapter 3B could be regulated by state enactments under Kerala.
By state enactments.
Money.
By state enactments. But here it is not so. It is Companies Act. Both are parliamentary
Anyway,
legislation.
my lord, we'll argue it fully whenever your lordship fix it.
In our case, it is both parliamentary legislation.
So what?
And there is
one parliamentary law can prevail over another. I mean, I don't understand why.
Where are the questions which have been framed in this appeal?
Lordship, give me a moment.
The grounds of evidence. Only the grounds.
Only in the writ petition you raise points of law.
No, points are
My lord, may I suggest it might be of assistance to your lordship. If your lordship fixes the date for hearing, I'll give a 3-page written note formulating the points and the judgment so the hearing can be cut short.
Yes. We have heard Sari Salvel and senior advocate appearing from Mr. So-and-so, learned counsel for the appellant, and Mr. So-and-so, everybody. The appellant had filed the writ petition in WPA so-and-so number, get the number, praying for push this screen. Push this. Push. Nothing will happen. Push, man. Praying for a writ of declaration to declare the Investor Education and Protection Fund within bracket uploading of information regarding unpaid and unclaimed amounts lying with companies bracket close rules 2012 and in particular rule 3 insofar as they purport to apply to unclaimed deposits in the hands of non-banking financial companies within bracket NBFCs and residuary bank non-banking companies be declared as already we have said declared, no? As unconstitutional, illegal, and void, and to be struck down. Alternatively, the appellant prayed for a writ of declaration that 2012 rules do not apply to NBFCs and residuary non-banking financial companies, and that NBFCs and residuary non-banking companies are exclusively governed by the Reserve Bank of India Act, and in particular, Chapter 3, capital, Roman 3, capital B. There were other subsidiary and ancillary reliefs sought for. The writ petition was not the writ petition. The matters had a checkered history, and a writ petition in WP 1558 within bracket W of 2007 was filed before this court, in which an interim order was granted on 6/3/2007. The sum and substance of the order is to direct the appellant herein to keep the deposit amount in a separate account with a nationalized bank within a time frame. There were series of other orders passed in other writ petitions as well, and the matters were being heard by the court, and ultimately the court passed an interim direction directing the appellant to escrow certain sums of money which the appellant had complied with. In or about October 2014, strike that out. Between June 30th to July 22nd, 2014, an inspection was carried out by the Reserve Bank of India on the appellant under Section 45 capital N of the Reserve Bank of India Act 1934, with reference to its financial position as on March 31st, 2014. Pursuant to such inspection, a communication was sent to the appellant dated by the Reserve Bank of India. You can abbreviate it as RBI. The Reserve Bank of India, dated October 31, 2014, wherein specific reference was made to the inspection under Section 45 capital N of the 1934 Act. The direction in the said communication, the appellant was required to repay all the deposit liability by June 2015, that is less than 1 year from the date of the said communication, and also the fact that unclaimed deposits are huge, appellant was advised to escrow the aggregate deposit liability, at the earliest, not later than 3 months from the date of the said communication. There were annexures to the said communication, of which Annexure 2 dealt with the operational guidelines for opening of escrow account shall be in terms of the said annexure. Pursuant to the said communication, the appellant addressed the Reserve Bank of India seeking for Reserve Bank of India on 2nd December 2014, seeking for certain clarifications. With particular reference to whether the interest on the unclaimed on the FDRs in escrow account equivalent to the entire ALD, all capitals, would be accrued to the company or not. There were other queries which are also there were other clarifications which are also sought for by the appellant. In response to the said communication, the Reserve Bank of India, by reply dated February 3, 2015, had clarified the various issues pointed out. And with regard to the interest component, it was stated that subject to the company maintaining amounts not less than the amount stated in column A within bracket 1 to 3 of the annexure to the communication dated February 3, 2015 in the escrow account and producing a certificate from the auditor to that effect to the satisfaction of the bank maintaining the escrow account, any interest received by the company on investments in fixed deposits / government securities could be available to the company. Thus, it is contended by the learned senior counsel for the appellant that in the direction issued by the Reserve Bank of India being statutory in character was acted upon by the appellant, and the monies which were accrued as interest were brought into the books of the appellant, and taxes were also paid under the provisions of the Income Tax Act 1961. Much after the said clarification, it is the registrar of companies who had issued certain directions, which has now resulted in which necessitated the appellant to approach the writ court for the aforementioned reliefs. The which place they raised the supply. Just raised, I saw it just now. The writ petition. Yes. Yes. In the writ petition, the appellant had raised certain points of law, namely as to whether the provisions of section 205 capital C of the Companies Act 1956 have any application to the case of the appellant company, which is an NBFC as defined in the 1934 Act, and a residuary non-banking company as defined in the directions of the year 1987. Further, whether section 205 C of the Companies Act is necessarily restricted in its application to non-banking financial companies whose deposit acceptance activities are governed by the provisions of section 58 capital A of the Companies Act, read with the companies within bracket acceptance of deposit bracket close rules 1975. The appellant had also raised the question as to whether whether applying the provisions of section 205 of the Companies Act to the residuary non-banking companies would result in conflict between the provisions of the RBA Act and the residuary non-banking companies within bracket Reserve Bank Directions 1987 on the one hand, and the provisions of the Companies Act 1956. Several other questions have also been raised in the writ petition. The learned writ court, though agreed on certain issues with that of the appellant, ultimately by the impugned order, the writ petition has been dismissed with a direction to the appellant to with the direction that the amount invested in the escrow account pursuant to the directions of the court for the sums lying originally with the appellant company after the expiry of 7 years of remaining unclaimed, along with the entire interest accrued thereon, shall be disbursed in favor of IEPF, all capital, subject to deduction of the statutory charges and or expenses deductible by the Office of the Registrar General of this court for investing and maintaining the said accounts, if any, and such disbursal to be made within August 31, 2023. After we have heard the learned submissions of the learned senior advocate, appearing for the appellant and the learned senior advocate appearing for the Reserve Bank of India, as well as the learned advocate appearing for the registrar of companies, we are prima facie satisfied that there is a question of law to be decided in the present appeal as regards to the effect of the provisions of the RBI Act, where the provisions of the Companies Act and other directions. The learned senior advocate for the appellant had placed reliance on the decision of the Honorable Supreme Court in Nedumbulli Finance Company Limited versus State of Kerala, 2022 7 SEC 394. This decision has been pressed into service to buttress the submission as regards the supremacy of the powers of the Reserve Bank of India under the RBI Act, and more particularly the 47. More particularly section 45 capital Q, which is contained in chapter Roman 3 capital B, which states that the provisions of the said chapter shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by virtue of any such law. Further, it is submitted that in terms of the said decision, the directions issued by RBI are statutory in character and binding on all NBFCs. Several paragraphs of the decision were also referred to. Thus, we are of the view that the appeal the appeal has to be entertained, and accordingly the appeal is admitted. Since the learned single bench has directed compliance of the directions issued in the penultimate paragraph of the impugned order to be done by 31st of August 2022 and 2023, and the appeal cannot be heard within the said period, the said date for compliance stands extended till 15th of December 2023. In the meantime, the appellant shall prepare the paper books and advance copies be served on the learned advocates for the respondents. List the appeal for under the caption for directions. Sometime in September, we list it for directions.
Yes, whenever convenient.
And then after everything is complete, we fix a date for hearing.
Yes, deeply obliged.
Time given by the judge is extended. Listed on 19th September.
Deeply obliged.
Yes.
Much obliged.
But, maybe just file the affidavits of service, it's a formality.
We are obliged to receive anything, sir.
No, we have
everything you file here.
No, it's just
2.5 months we are receiving, say.
No, it's only the affidavit of service. It's only the affidavit of service.
We have appealed.
Well, just to show that service was affected, those are here.
Yeah, they are all there.
Yes,
Senior
yes.
counsel is appealed. There are only 2 respondents.
Yes.
All right. We'll go back to that gas agency matter.
Affidavits of service, but I don't need.
You please file it. Deeptesh. Affidavit of service taken on record.
So, the formality, which we will have to do, perhaps not required.
Because I am not accustomed to this, because there most of the courts don't entertain anything across the court. because you don't get a register number.
I
They call it USR number. So what they'll do is you go get a USR number, then convince somebody to carry that here. We'll put it.
right. I'm aware, my lord. I have some, my lord, experience, my lord,
So,
before. My lord as well, my lord. There.
You get a filing number.
Yes,
and,
that's right.
Now that is online. So nobody can say that no affidavit was filed. See, you say what is the affidavit, what is the content. Content's not known. At least the title.
Title affidavit of service.
Affidavit of service.
Correct. Absolutely.
They have got abbreviation for that. AOS. This one. This. Anyway,
We should not. Maybe we should have that.
Probably we'll have one register here. We'll also start assigning numbers.
No, that can't be, my lord.
Anyway,
Grateful, my lord.
Grateful.
Item number 14.
14. For my learned friend starts, I shall take only 1 minute time.
yes, sir. Please, sir.
My lord, I have placed before your lordship the civil court order.
Yes.
But one order have not been placed. Your lordship, kindly turn up to
One second.
page 106. The civil court order. And page 107 is the order. This is an order dated 20th of March 2019, filed by my client in a suit. Restriction order passed, page 107. That the defendant number 1, that is the private number 9, restrained from interfering with the management of the suit firm as mentioned in the schedule of the plain till so and so, that has been extended.
Yes.
But against that, an order 7 rule 11 has been filed for cancellation of the plain. Kindly turn up to the next page, page 108. Elaborately considered all aspects of the matter.
That also dismissed.
That has been dismissed. And another document I have not placed, I have submitted before lordship that
And against that, no revision.
against that revision, that which I have shown to your lordship.
Oh, it is not against this.
No, first order. It is the order in cancellation of their application for rejection of the plain against that suit, revision. Against that revision.
So against.
Order 7 rule 11 was on the issue that the suit is not barred under section 69 of the partnership.
That's for that. Point of maintainability. Yes. Whether by partnership, whatever may be, against that revision has been filed. So far the main order is concerned, no revision. That's my submission.
Okay.
So far the injunction is concerned, no revision.
No revision.
Injunction revision does not lie. It has to be a miscellaneous.
Whatever may be, my lord, that I have submitted wrongly, I have not, so far your lordship is concerned, I cannot open my mouth. But injunction order remains no
unchallenged. According
to
to
your lordship, another document I shall show to you.
What is that CO? Civil order?
My lord.
The civil order which.
That is page. My lord, I have annexed to.
From what
Yes.
order that civil order has been filed?
My lord. My lord, that I am showing to you. That order I have annexed at page.
Page 120.
120.
120. 120 হচ্ছে এসি ওটা।
There is no reflection.
There is no indication.
No reflection, nothing. But subsequent to the rejection of their application for cancellation of claim. My lord, another document, if you lordship kindly turn up to page 117.
Page
117, 117.
Yes.
This is a letter of the learned advocate of the appellants dated 22nd of July 2019 at page 117.
Yes.
But kindly turn up to page 118.
Yes.
Second paragraph. In the letter dated 11th July 2019 under reference, you have mentioned that the Srimati Rinadatha 50% shareholder of the so-and-so such despite your specific knowledge. Srimati Rinadatha shareholder of the state partnership firm, whereas other two partners 24% such each. In spite of a specific knowledge that the partnership deed so-and-so has been supplemented by supplementary registered partnership deed executed on 15 September 1993 amongst the partner. While it has without any uncertain term been agreed upon by all the three partners that henceforth Srimati Rinadatha will be 1%, shareholder of the partnership firm and will not be able to do any partner so on so on. So the next paragraph. Lastly, copy of such registered supplementary deed dated 15 September 1993 has been forwarded to you by my client under his covering letter dated 25th March 2019. So it is apparent that despite specific knowledge so and so. So my lord, on 22nd of July 2019, copy of the supplementary partnership deed has been forwarded to the oil company. They are very much aware. They are very much aware that a supplementary partnership deed changing the share of profit.
That is where the problem started.
No, no. Kindly come to page 143.
That is where they triggered the matter.
No, I am saying no, my lord. Page 143.
Until then, they were keeping it a secret.
No, before that they have
brother and sister.
Before that they have issued the show cause notice. Kindly turn up to page 115.
Okay.
Before that, no whisper about this. Kindly see why I am showing show. Page 115. Copy to Manmohan Datta, page 116, and Bhutnath Datta. Much prior to that, this is 11th of July 2019. Addressing Rina Datta, copy page 116, both the partners, both the appellants.
Mr. Sahara, do you have a copy of the plaint of the civil suit?
Just now, I can hand over subsequently. Just now it is not with me. Just my friend. So on page 115 is prior to my intimation.
All right. We have noted that.
So 22nd July 2019, my communication. Then again another communication. Why I am showing show. Page my lord 123. Again. Share up, profit, everything I have intimated. Then what is the reply? Kindly turn up to page 143. 143. Come and endorse your signature. Despite knowledge, you have accepted it. There is no whisper, we are not accepting your subsequent partnership deed. Come and sign. So it is accepted. Page 143.
Yes.
Addressing to my client, last four paragraph, 143 and 44. After receiving copy of the supplementary partnership deed, both the partners that the appellants have been directed, instructed to sign and endorse your signature, along with Rina Datta. So despite knowledge, they have never said that we are not accepting your proposal. Because this does not come within the purview of clause 21.
That we will consider. No, please don't rewind. We'll forget otherwise.
Get through.
Yes, sir.
My lord, I am appearing for the oil company.
Oil company.
My lord, whether your lordships will invoke writ jurisdiction, my lord, for renewal in a agreement which is determinable by character, my lord.
So writ is not maintainable.
Writ is not maintainable, my lord. That's my submission. Now, my lord, so far as the suit is concerned, we are not a party to the suit. Lordship knows. My lord, I do not know, my lord, unregistered partnership, my lord, how section 69 was rejected. My lord, that was something surprising for me, my lord. Order 7, Rule 11, my lord, that's in between them. I should not delve into it. But my lord, it's little surprising, my lord. Lordship, they were showing last, I'll start with where they ended, my lord. My lord, they had just demonstrated before your lordship one letter which is in reply to our letter, my lord. Our letter is at page 85. Because they just showed it, I want to, my lord, start with that. My lord, page 85 of my opposition, my lord. Lordship, my opposition, lordship will take. Oil company's opposition. Page 85. ওই তুই যে সিঁড়িটা দেখালি ওইটাই my lord, as late as 11/7/2019. My lord, last extension was in June 2017 till June 2022.
Last extension was from 4/6/2017 to 3/6/2020.
Lordship. So this letter is in between, page 85, 11/7/2019. My lord, we address to them.
This is the show cause notice.
Yes, where we have mentioned that, my lord, we have mentioned that Rina Dotto is 52%.
Yes, as per the original agreement.
As per the original agreement, my lord. To which they give this reply, saying this, we have done this. The reply is was shown by my learned friend, my lord. The reply at page
117
of their, my lord, vis-a-vis this, I'll take your lordship to one document filed with an affidavit of my learned friend, my lord. Lordship will take that affidavit once. No, please.
Which affidavit?
My lord, page
Affidavit or
34.
supplementary affidavit?
My lord, this is an affidavit dated.
You tell the page number, we'll check up.
My lord, page 34.
Then it must be affidavit.
Yes, page 34.
34.
34. My lord, it's named as affidavit of respondent number 9.
Yes, yes. 34 is explosive license. No, income tax.
Income tax.
Statement.
Lordship has got it?
Yes.
My lord, Lordship will see name of the assessee, Buroma Gas Service.
Yes.
Lordship will come to the heading number 7. First, number 6. Assessment year 1999-2000. Number 7, if firm or association of persons indicate names of partners, members, and their profit of sharing ratios, Lordship sees thereafter. Rina 52%, Manmohan 24%, Bhutnath 24%. And who is filing this? One of the appellant petitioner before your Lordship in 2000, 2001.
But the reconstitution, not reconstitution. So I'll say it's
93.
93.
93. So even they don't believe it has taken place. They still believe in this.
No. Otherwise, you will pounce on them. That's why.
Malat?
Otherwise, you will pounce on them. That's why they don't want to show.
Because we are not bound in terms of the agreement. That I'll demonstrate now. Malat, this is what they are. Malat, they have not disclosed this. Not coming with clean hands before your Lordship. They still rely on this. Officially. Malat, after this, Malat, can they make any argument? Before a statutory authority, they are saying this is the partnership ratio.
Okay.
Lordship, I'll take your Lordship through that clause 21, my lord.
That's the only legal interpretation.
No, there's something else also, my lord. First, 21, of course. My lord, 21, some portion, my lord. Lordship 21, from my affidavit, Lordship. Or from wherever your Lordship has marked it.
We have marked it in page 57.
Page 57. That is my affidavit. That is the affidavit of my learned friend.
Yes.
I'll read it from there only. The distributor shall not sell, assign, mortgage, or part with otherwise transfer his interest in the distributorship of the right interest or benefit conferred on him by this agreement to any person in the event of the distributor being a partnership firm, any change in the constitution of the firm, whether by retirement, introduction of new partners, or otherwise. The word otherwise is also there, howsoever. So, in the event distributor being a partnership firm, any change in the constitution of the firm by this or otherwise. So, my lord, even if there is a change of the percentage of shareholding, that would come under this. Now, Lordship, vis-a-vis this, Lordship will kindly come to the next page. Clause 23, C, Roman 3, page 58. This has not been shown to your lordship.
You are showing it now. Very good.
Clause 23C, Roman 3. If the distributor, if it be a firm or a cooperative society, my lord has got it, shall not affect any change in the constitution, whether in the identity of its partners or appointment of whole-time office bearers or elected members or in terms of the deed of partnership. So the term stipulates what would be the shareholding. So they will not change the terms of the deed of partnership. Yes, my lord, lordship will excuse me. 23C starts except with the previous written consent of the corporation. 23C starts with except with the previous written consent of the corporation. This he cannot do. And this express would include, my lord, change in the partnership ratio. My lord, thereafter, my lord, let us go to the my lord, memorandum of agreement, my lord, which supplementary agreement, where they showed clause 2, my lord. My lord, I will draw your lordship's attention to clause 9 as well. Page ta koto ache? Supplementary. My lord, I think I'll have to rely on my affidavit.
No, it is there in page 69.
69. 69. But however, my lord, it's not in that order. My lord,
69 is the supplementary agreement which was entered in the year 1993. You want that agreement or the first agreement?
It's not here. That can now close.
You can take this one, sir.
No, my lordship, I will draw your lordship's attention to page. Where is that document? Yes. Lordship will come to page 36 of my affidavit, my lord.
Your affidavit.
I don't know, my lord. Actually, it starts from 33. My lord, this apparently looks same, but I don't know. My lord, page.
All right, you go proceed in your own way.
Yes, my lord. Page 33 of my affidavit, lordship has got.
This is 1992.
1992. Yes. 1992. Lordship has seen clause 2. Lordship has
one second.
No change in the constitution of the partner.
Yes.
Clause 4, if any of the partner willing to retire from partnership, he or she will have to take prior permission of the corporation. And 9 thereafter, my lord, no change in the partnership shall be made without formal approval of BPCL. My lord, their best case is they had given the supplementary agreement executed in 1993 in 2019. In March 2019. Prior to that, it was not given. At least they have not demonstrated from any document that that document came to us. Now, my lord, lordship will kindly come to the next page of my affidavit, page 39, which is again very important. Page 39. My lord, it was in 92 when we allowed reconstitution. We said that there will be no voluntary reconstitution for further period of 5 years and the name of the dealership should remain unchanged.
So in 93, they did the change.
93, they did the change. They never informed us, my lord. And
according to them, it's not a change.
Not a
according to them, it's not reconstitution, but according
that
to
we'll
us,
decide. That
yes, according to us, that is reconstitution. Now, lordship was looking at this supplementary agreement. Supplementary agreement. From their affidavit only, lordship will come to page 72, paragraph 4.
Yes, sir.
Page 72, paragraph 4. This is the supplementary, one of the clauses. That partner Rina will enjoy her share till her lifetime, and after her death, her share will revert
Wait, sir, wait, sir. 72
of their affidavit. Yes. My lord. Oh, their petition, stay petition. কিছু করার নেই ভাই, পেপার বই না থাকলে তাই হয়।
It is also in your affidavit.
Yes.
Page 59.
Yes, my lord.
Same thing.
Yes.
All right.
Page 16.
Page 72.
Yes. My lord, partner Rina will enjoy her share till her lifetime, and after her death, her share will revert to other partners, and the heirs of Rina Dokto will have no claim. My lord, this is absolutely contrary to our, my lord, guideline, which is appearing at 64 of my affidavit. Lordship, I'm extremely sorry. In absence of a paper book, my lord, lordship has to travel from one document to another. My lord, page 64A, really I'm harping at 64A. My lord, proprietor partners of existing distributorships may nominate, it's clause 3.1.1. In the form to be prescribed person, he/she desires to transfer his share in the event of his or her death or incapacitation, resulting in total and permanent disability, which will disable the proprietor partner to work or follow any occupation or profession. Such nomination can be made in the name of legal heirs and family members and otherwise. Now, my lord, thereafter, I have shown to your lordship 65. Nah? Page. Page. Now, my lordship has seen in all the agreements, the agreement were for 5 years, and lordship also, my lord, the clause of determination. Lordship will take any of the agreements.
Page same, your set, you take page 65.
My lord,
there is arbitration clause, etc.
Yes.
What do you want to refer?
My lord, the determination clause, my lord. That the agreement is determinable.
Clause number?
My lord, clause number 28, my lord, page 26 of my affidavit.
Notwithstanding anything contrary.
The corporation shall also be at liberty at its entire discretion to terminate this agreement forthwith upon at any time after happening of any of the following events, namely, my lord, the clauses are given. And thereafter, my lord, after the clauses, my lord, up to running up to N, the corporation's right to terminate this agreement under the terms of this clause shall be without prejudice to and without affecting any of its rights and remedies against the distributor, my lord, etc. So it's a really determinable contract. My lord, why I was referring to, okay, okay. Why 27?
Which other clause you want to rely?
Yes, lordship. Why I want to show this, I'll just demonstrate, my lord. Page 28. Because, my lord, in view of specific relief act, my lord, in view of section 14 of the specific relief act, lordship will take a look at section 14. My lord, this is vis-a-vis
No, we'll share the book, you read.
clause 28. My lord, contracts not specifically enforceable. The following contracts cannot be specifically enforced, namely, lordship will come to D, a contract which is in the nature determinable. Now, my lord, with this proposition of law, my lord, I was referring to a judgment of the Honorable Supreme Court, my lord, where it was between Indian Oil and a particular LPG supplier, like my learned friend, my lord. My lord, my lord, I'll read only two paragraphs from this. My lord, paragraph 2, my lord, a distributorship agreement dated 1/4/1976 was made between Indian Oil Corporation and Amritsar Gas Service respondent number 1 as distributor of the corporation for sale of corporation's LPG, known as Indian, in cylinders only for household consumers and commercial customers in the area of Amritsar. The terms of the condition of distributorships were specified in agreement. Clause 27 of the agreement provided for termination of the agreement by the corporation forthwith on happening of any of the certain specified events. Clause 28 permitted either party without prejudice to the foregoing provisions or anything to the contrary contained in the agreement to terminate the agreement by 30 days notice to the other party without assigning any reason for such termination. Clause 37 provided for adjudication of any dispute through arbitration.
Yes.
Now, my lord, there was a dispute, the parties went to arbitration. My lord, in the arbitration, my lord, the learned arbitrator came to certain finding, but found the termination to be illegal. My lord, that was challenged under 34 and went up to the Supreme Court. My lord, paragraph 11 is the portion, paragraph I'll be referring to your lordship. The arbitrator recorded finding on issue number 1 that termination of distributorship by the appellant corporation was not validly made under clause 27. Thereafter, he proceeded to record the finding on issue number 2 relating to grant of relief and held that plaintiff respondent number 1 was entitled to compensation flowing from the breach of the contract till the breach was remedied by restoration of distributorship. Restoration of distributorship was granted in view of the peculiar facts of the case, on the basis of which it was treated to be an exceptional case for the reasons given. The persons given state that the distributorship agreement was for an indefinite period till terminated in accordance with the terms of the agreement, and therefore the plaintiff respondent number 1 was entitled to continuance of the distributorship till it was terminated in accordance with the agreed terms. Now, lordship will kindly skip up that page and come to the first line on the next page. This finding, read along with the reasons given in the award, clearly accepts that the distributorship could be terminated in accordance with the terms of the agreement dated 1/4/1976, which contains the aforesaid clauses 27 and 28. Having said so, in the award itself, it is obvious. Having said so, in the award itself, it is obvious that the arbitrator held the distributorship to be revocable in accordance to clause 27 and 28 of the agreement. It is in this sense that the award describes the distributorship agreement as one for an indefinite period that is still terminated in accordance with clauses 27 and 28. The finding in the award being that the distributorship agreement was revocable and the same being admittedly for rendering personal service, the relevant provisions of the Specific Relief Act were automatically attracted. Subsection 1 of section 14 of the Specific Relief Act specifies the contracts which cannot be specifically enforced, one of which is a contract which is in the nature of determinate. In the present case, it is not necessary to refer the other clauses of subsection 1 of section 14, which also may be attracted in the present case, since clause C clearly applies on the finding read with the reasons given in the award itself that the contract by its nature is determinable. Now, pausing here for a moment, my lord, before the Specific Relief Act was amended.
You please read the next two lines.
Yes. This being so, granting the relief of restoration of the distributorship even on the finding that the breach was committed by the appellant corporation is contrary to the mandate of section 14(1) of the Specific
So that's
Relief
your argument. That's your argument.
Yes, Specific Relief Act as it stood
Yes.
then has been amended, my lord. Now it's no more 14(1) is there. My lord, it has now been amended. It will appear from the book itself. It is 14D. Lordship, I missed one thing. Only one I want to show. My affidavit, page 50. My lord, just to equate without assigning any reason part.
Yes.
page 50, paragraph 28.
Clause 28.
Without prejudice to the foregoing provisions on it or anything to the contrary herein contained, either of the parties hereto, namely the corporation or the distributor, shall be entitled to terminate this agreement on giving 30 days notice to the other party without assigning any reason for such termination. My lord, here question of termination will no more be applicable because it has already been determined in June 2022. Question of renewal will arise, my lord. My lord, we may be at liberty. This is a commercial contract, my lord. My lord, it's absolutely our discretion whether we want to continue with him or not, my lord. Is it not as of right, my lord? And my lord, none of the fundamental right in that sense has been infringed, my lord. And it's absolutely a private dispute, my lord, which is really brought under the purview of section 226, my lord.
Yes.
My lord, those are my humble submissions.
I have the copy of the plane, my lord, just now I have.
You can circulate it.
So my lord, if your lordship kindly come to page 148
Of your
of the, my lord, the stay application.
148.
Lordship. My lord, this the deliberately they have not annexed the first, my lord, the partnership deed, neither in the writ petition nor, my lord, my affidavit in opposition, which has been filed before the, my lord, the single bench, my lord, that has not been annexed. My lord, kindly come to 148. If that, my lord, the agreement is, my lord, annexed with the, my lord, main writ petition, so no extent and no interim order can pass. My lord, kindly come to 148.
Yes.
My lord, is the learned counsel appearing for the petitioner seeks to file a rejoinder to the affidavit on behalf of the private respondents. So in that rejoinder, I have filed, my lord, the first agreement which has been, my lord, executed between the my brothers and my lord, my petitioner. Now, my lord, that document has not been filed neither in the also my lord, in the stay petition.
But you have filed.
No, here they have not filed.
You have filed.
I filed. Now, my lord, is kindly come to, my lord, my lord, affidavit. My lord, I had of the submission of my land, only, my lord, I pointed up to. So my lord, kindly come to my affidavit, page 2. My specific, my lord, the contention is this: the pursuant to the, my lord, paragraph 4.1. The pursuant to the advertisement made in the Anandabazar Patrika 1 Sergeant Sat for the Bharat Gas distribution ships, the answering respondent applied for the said partnership. It is further submitted that the answering respondent number 9 was the only graduate members of her family, and after complying, my lord, she is the only till now. I am saying, my lord, in their affidavit opposition, so now they have not controverted that submission. Now, second submission before the lordships. Now, the advertisement which has been made in, my lord, that statement which has been made in on oath in my petition. Now, kindly come to page 23 in Bengali, my lords. The condition, aged should be, my lord, 21 to 35 years and graduate. So I am the only candidate, my lords, amongst my family members. I got the, my lord, the dealers. Now, my lord, is kindly see there is a certain condition of the guidelines framed by the policy guidelines by the oil company. Policy guidelines is this: at that relevant point of time when I was unmarried, they did not take any steps. They are taking all the benefits from my business. So under compelling circumstances, I executed, my lord, the partnership deed in 1992. So now, my lord, is kindly see there is a certain condition. If I willing to, my lord, opt up, my lord, the certain my two brothers, then the certain procedure is the draft deed has to be submitted before the corporation. So that is the, my lord, the page. Kindly come to page 24
of yours.
My lord. I approach.
Yes.
So that is the, my lord. Then I have been directed to submit a, my lord, this the draft partnership deed. I then thereafter, my lords, on 5th of June, after considering the same, the authority concerned, my lord, this allowed to, my lord, this execute the partnership deeds. Now kindly come to page 32.
Yes.
32, it is the, my lord, specific terms and conditions. Now the execution of my partnership deed on 5th of June 1992. And supplementary, after execution of that deed, they did not take any step for my marriage. Again, my lord, under compelling circumstances, kindly come to no further change can be made within 5 years. But since I was unmarried, they did not take steps. Again, my lords, kindly come to page 32. No further change to be made within 5 years. 1993, they did not take steps. Then on influence, my lord, signed this document, admittedly. Until my lord, my lord, thereafter they have arranged my marriage. I went to my matrimonial house. When she was pregnant, she dived out from her matrimonial house. Then she to shelter his parent house. After demise of my lord, this husband, again I have been there by my 2 brothers. Now, my lord, pursuant, I am not showing my lord other documents. My lords, pursuant to a lordship direction, I sit along with my learned brothers' clients. Kindly see my proposal. My lord, 3 brothers.
That we will not.
No, I am not. What is my proposal? My proposal is this. This agreement is totally, my lords, under influence in violation of the.
Please don't go into that.
No, I now.
Now Supreme Court has directed the appeal to be heard.
Lords,
Here.
no.
Question of law, he has made submission.
No, my lord, my submission, supplementary deed, which has been whether in accordance with the guidelines or not.
That he has argued.
So now this is the guideline I have annexed to my supplementary affidavit. My lord, guideline which has been, my lord, is the clearly, my lord, this the guideline says.
Page
My
7.
page, my lord, this is irrelevant portion, my lord, I am showing my page 7.
Page 7 of supplementary affidavit.
Lordship. Now it has been, 8 is the very relevant, paragraph 6. Induction of outside partners can be permitted in case of para 1, 2, 3, 4, and 5 above, subject to such reconstitution meeting all other criteria, including retention of minimum 51% share by the original allotee. I am the original allotee. So if my lord is that 1%, my lord, till now, though they have submitted the income tax return, showing that my share in there, my lord, 52%. In 2002, they have also, my lord, yes, you will get your benefits, profit of that share. Till they, my lord, they have not. That is, my lord, only submission. If any supplementary is made, contrary to the, my lord, the guideline policy contract, that, my lord, supplementary deed is required. Great.
Before he replies, my lord, just one document in my affidavit.
Contains a clause that all conditions should be.
One another submission. Subsequent, they have suspended without giving an opportunity of hearing. That's why I file an application, writ petition before pending before the my lord Justice about child. So, my lord, why
suspended? What they suspend?
Suspension or my lord the dealership?
Oh, you are the reason for such suspension. Oh, you can challenge it.
No, because of the entire, my lord, this partner can be resolved. My
you because of your action, everything is gone according to them.
No, my action.
Action in the sense, according to you, compelling circumstance.
That part, give my opportunity, my lord. Opportunity has to be given, my lord.
My lord, only.
Where is the question?
My lord, so, my lord, that is the without my lord. Personally, the order of this court, my lord, I approach before the as per the clause 8.
Now we are on legal issue. That's
my lord, only one document, page 95 of my affidavit, my lord.
What is that document?
My lord, page 95. My lord, this is, my lord, a further deed of partnership executed in between the writ petitioner's appellant, excluding him, which was deposited with us during this, my lord, settlement meetings.
Okay.
Lordship will kindly see page 95.
With a fond hope
My
that.
lord,
you
this
will
has been
accept-
suppressed. This has been suppressed. This is a document of 2018 between the two brothers.
Okay.
Deed of reallocation of shares. The sister is not a party. And this was deposited with us sometime during those meetings which were held. My lord, those are my humble submissions. My lord, I may be excused, madam.
Just 2 minutes.
Yes.
My learned friend, Mr. Mal has addressed before your lordship that writ is not maintainable, appeal is not maintainable. The order of the learned single judge neither have been challenged by the oil company or the private respondent. Single judge rightly, wrongly entertained the writ petition and passed an order. So point of maintainability at this juncture in the appeal without preferring any appeal order of challenging the order of the learned single judge does not arise. The submission advanced that writ is not maintainable, appeal is not maintainable. They have accepted the order of the learned single judge, where the learned single judge entertained my writ petition and passed an order, maybe in against my view. And a public sector undertaking, when committing fraud before the division bench, your lordship kindly take up their opposition. Policy guideline has been placed before your lordship. Kindly turn up to just my learned friend from their opposition, page 33. That has been placed before your lordship just now.
33 is partnership.
No, sorry. Oil company দেখাচ্ছিল যেটা। Page 85, my lord. Sorry, my lord, page
95.
Page 9. No, my lord.
85.
85. From opposition.
Page 85.
85 is show cause 11-7.
Condition just a minute, man. Just have
You, what is the document you'd like to show?
policy guideline.
Well, that is in.
Come from the oil company has shown before lordship.
That is in the 9th response.
Page 64A. That is there also. Before that, page 64 of the opposition.
Ah, yes. This is 2022. This is 2022.
So there, your lordship has gone through.
Yes, yes. The other one is also latest one.
That is 2018. So 94, there was no guideline in respect of reconstitution.
But then why is that magic figure of 51%?
Nothing, nowhere. This is coming just for a moment.
Your territory manager will advise you, sir.
Reconstitution policy framed by the government, oil company.
What is your answer for that, sir?
And kindly see, my lord, their affidavit.
I'll call your advocate. What is your answer for this? They say that guidelines in page 64A of your affidavit is a 2022 guideline, cannot be made applicable. You ask your officer what is the.
And the first page has not been annexed.
In his document also, first page not annexed.
No, they have annexed page 7 of their supplementary.
No, first page is not there. Brochure.
Even reconstitution in the year last 22.
That's his.
2022,
His submission is
further isn't this
the regulation prevailing on the date on which reconstitution is sought for will apply. You can't set the clock back, sir.
Reconstitution,
You have enjoyed 3 renewals.
1993, which is their challenge.
No,
1%. They are saying
it's a contract which is not specifically enforceable, and it is a license. It is not a lease. It is a license granted.
I am possibly not in a clear position, my lord.
No, you are very clear.
No, what I want to say before your lordship, they are saying 1993 supplementary partnership is not in accordance with the reconstitution guideline.
Because reconstitution is being sought for as on 2022, because you up to
2019.
No.
Yes, kindly see knowledge. Kindly see the knowledge. The letter I have written to them.
2022.
I am not
Sir,
praying for.
3/6/2022, you had a valid distributorship
My
license.
first submission before your lordship, this is not reconstitution. My second
No, no,
submission,
that
no,
you-
my second submission.
We'll
before-
forget them.
Second submission before your lordship, that this guideline which has been annexed by the oil company is for 2022, that has no retrospective effect in the year 1993. And so far the private respondent is concerned, they have annexed a document, kindly come to page 7 of their supplementary affidavit.
Yes.
Kindly see the first paragraph. Relying on this document, my learned friend says, by use influenced, I got the signature. Kindly see the first paragraph, last line, page 7, supplementary affidavit. Which had been brought into effect 4th of July 2018. Have your lordship got last line, first paragraph, page 7. Introduction. So 1993, there was no guideline in respect of reconstitution.
Correct, correct.
Yes. And so far my almost submission in all respect, this is not at all a reconstitution. This,
We have heard the judgment reserved.
and man, subject to our lordship consideration, they have suspended in terms of,
yes.
no,
Oh,
and that has been revoked. That has already been revoked.
Supreme Court order.
Madam, revocation order.
Respondent number 9.
Sir, please take note. By order dated
suspension order withdrawn and
1 second.
that hand over the Supreme Court order.
By order dated 5th July 2023, the order of status quo granted was vacated. The appellant had filed special petition against the said order before the Honorable Supreme Court, and by order dated 18/7/2023, the Honorable Supreme Court disposed of the special petition by passing the following order, dated 18/7/2023. Please extract the entire order. In terms of the above order, the suspension of supplies notices dated 7/7/2023
this is the order.
shall continue in force till 26/7/2023, the date on which the appeal was to be heard by this court.
But this is the revocation order of suspension.
After the on the next date, no, before the but in between you moved the other bench.
Yes. Since an order of suspension, your lordship may remember I mentioned this matter. Your lordship fixed the matter, but since the bench didn't sit, we mentioned the matter and interim order has been granted.
Before the hearing of the special petition, the appellant had mentioned the matter before the another honorable division bench, having determination on the particular day, namely 14/7/2023, and the honorable division bench by order dated 14/7/2023 directed that the suspension of supplies notices dated 7th July 2023 shall remain stayed till the issue with regard to suspension is considered by the Supreme Court or by the regular bench of this court, whichever is earlier, and shall abide by any order to be passed by the said courts. Second portion of the order is in clear violation of, and by virtue of mentioning, it's not heard of, sir. If you file an application, this is actually judicial discipline would mean that if you file an application for hearing, with a fresh cause of action can be done. This was earlier known as Calcutta High Court practice. You appear before me, press for an interim order, I don't grant. remove the file from my file, go to, was that practice prevalent in this court or not? Until the Honorable Supreme Court.
Your Lordship, remember, I meant that was.
So
that
therefore,
there are
the
some judgments.
second portion of the order is very damaging. See how the division bench, we heard you and we vacated the interim order. And thereafter you mention it, of course you are entitled.
Your Lordship,
because the jurisdiction was there.
matter was appearing in Your Lordship.
No, it
as
was
item number 22.
maybe, but the division bench can't say that I will stay the order till you hear the matter when we have vacated the order. What sort of?
Since the matter was pending before the Supreme Court.
No, that may be.
That has been.
If the sentence has stopped with that, it's fine. What is the next sentence? Or by the regular bench of this court, which this is sitting in appeal over our order.
You should not make any comment. I should not make
With great respect,
I should not.
we have certain reservations about the observations made in the order dated 14/7/2023. Though it would have been well within the jurisdiction of the court to consider a prayer for interim relief, but however, such a prayer was considered even without an application being filed.
We have filed an application.
Where is that application?
That is there. Application can number 2. That is filed.
All right, strike it out. Open to the division bench to consider the prayer for interim relief on the ground, since it was a submission of the appellant that the matter is being the order.
Just may I interrupt one second?
Order passed by this court dated 5/7/2023 is challenged before the Honorable Supreme Court. However, with regret we note that the Honorable Division Bench has observed that the interim order will continue, will remain, the suspension of supplies notices dated 7/7/2023 shall remain stayed till the issue is decided by the Honorable Supreme Court or by the regular bench of this court. In fact, the regular bench of this court which was hearing this appeal, that is our division bench, had vacated the order of status quo dated 5/7/2023. Be that as it may, since we have heard the appeal in full and the orders and judgment has been reserved, the order of interim, the interim order granted by the Honorable Supreme Court in its order dated 18/7/2023. No, the interim order granted. The order of stay of suspension of supplies notices dated 7/7/2023 shall continue till judgment is pronounced in this appeal.
But don't take any amiss to our. We have filed an application annexing the order of suspension.
That 13 years and 2 or 3 months, it has not happened to me. The ingenuity is all. Yes, you are in a chartered high court, sir. You are not chartered.
I get 1 minute time. 1 minute. Just 1 minute. Not more than 1 minute. Fifth order passed by your lordship vacating the interim.
We declined your. See, therefore, it is well open to you to file an appeal before the Honorable Supreme. We are not saying. No, we are not attributing anything to the learned advocate. We are not attributing anything, but we are very concerned about. Rather speaking for myself, disturbed about the last line. That last line tantamount sitting in appeal for our own order. A coordinate division bench can't be doing that. Can you expect that to be done in a chartered high court?
May I get 1 minute time? Just 1 minute. Just 1 minute. Otherwise, my lord, possibly, my lord, I should not be clear to my mind. Fifth, your lordship vacated the interim order. 7th, we filed the SLP. At 4:30, we have intimated the oil company. At 6:30, order of suspension has been issued. Annexing this order of suspension and the communication of the learned advocate on record of the Supreme Court, we filed an application on the very next day. Your lordship may remember I mentioned this matter. Your lordship directed the matter to appear on 17th. On that day, matter appeared in the list, but bench did not see. We mentioned the matter to the other bench. the learned other bench, coordinate bench, considering the time. That
on 14/7, there was no order of the Supreme Court.
No,
But you produce proof to show that you have filed SLP.
there is
So
a communication.
Therefore, we will be well within our jurisdiction to say that till the SLP is there, status quo be maintained.
Second part. I understand. I understand. I should not make any so far that part is not.
So you are
Our
not
contention was that till the matter is heard by the Supreme Court, suspension. That was our submission. But second part, I should not.
we are not.
I
saying-
understood. I understood.
But we record our dissatisfaction in the order.
Lordship, the next matter, my lord. My other side is here. my lord.
I've got to Lordship.
I have get hold of my other side, my lord. I don't know if there was an interim arrangement, my lord.
That interim arrangement, you ask is order from senior counsel.
By, he's leading, he's leading.
He's leading you, but who's the other side?
Chakraborty is sitting there. Arjit Chakraborty is sitting there. I'll issue.
Sir, that interim, without hearing, we can't grant any interim order.
Whenever I shall come tomorrow. day after
চক্রবর্তী
tomorrow.
আছেন, স্যার আপনি
tomorrow
পেছনে আছেন অরিজিৎ দা।
জজ সাহেব বলছেন যে এখন 4টে বেজে 20 বেজে।
Tomorrow it will come.
Tomorrow, day after tomorrow, any time. I don't want to unless.
What is Arjit going to do? Take your client off? Is it?
No. With deepest respect, I don't think there is any interim order for which
No,
just come.
They say some arrangement, some, who appeared additional solicitor, is it?
I tell you, Lordship, the very interesting point. The adjudicating authority, there is only one member
Correct.
and not a judicial member. The short question is whether the adjudicating authority with one member without the judicial member is a quorum non-judice or not. This is a short point involved. I lost it in the trial court. I am coming up before your Lordship. Interesting question, short point involved. I am sure my learned friend will be able to address your Lordship on this. This is a short issue. But the arrangement was this, that since the matter was pending before the court, there was sort of a gentleman's agreement that in the meantime, the adjudicating authority will not proceed. That was not what happened in the other Honorable Court of Appeal. So, that is what is being said, but my learned friend is absolutely right.
Occasion,
There is
with
no,
leave from my learned senior friend.
Speaking for myself, I am not accustomed to recording any of the
no,
submissions which
I
are made
don't
at the
want,
bar.
I don't want.
I have my own reservations about what has been recorded by the other Honorable Division Bench. It's up to you to sort it out. We can't be recording something.
No,
Otherwise, I have to record the submission saying that so-and-so counsel for the enforcement directorate says that he has instructed the adjudicating authority not to proceed further.
No.
No, his statement will not bind him, sir.
No, and not only that, I do not want to put
It's a very risky business.
him into embarrassment.
He'll be embarrassed. The court will be put to more embarrassed.
No.
And there will be
I do not.
at least he, as a member of the bar, you will protect him. Who's to
Of course,
protect
I
the
shall
court?
protect you.
Who's to protect the court? There are nobody for us, sir.
Of course, I should. No, I am not going to put him into any embarrassment at all.
Let it come in the list tomorrow. We will see.
Very well.
Thank you.